Item 501.
My learned friend who was on his legs on last day says that he would take 4 minutes. I'll start after that.
Today you're saying something?
Yes, ma'am.
You're saying something, I missed.
Yes, ma'am. I'm sorry. Lord, I was to start,
Yes.
but my learned friend, my Lord, who was arguing on the last occasion, has requested that he has few minutes to argue. I'll argue, my Lord, after he completes.
Sure.
Because there's one item 501.1 as well, Milots. I would like to address just for 5 minutes because that arises out of section 9, Milots, not under 11 and 8. 5.
Please, my lord, before he commences, Mr. Sibal had concluded his arguments on Thursday,
Yes.
seeking permission to file a note on arguments on his behalf.
Yes, yes, you can file that.
Great.
And you email a soft copy to the court master.
Yes.
Because I had submitted a note,
You are in IA 58168.
my lords.
Yes, Ms. Plonge.
Because I've tried to deal the questions that have fallen for my lords in the last 2 dates. The first question that fell for my lords is how do you infer conduct under section 7? Where is the rule for conduct? My lords, in my humble submission is, my lords, that the provision of section 7 is pari materia to the New York Convention, Article 2.2. And generally, there's a handbook of judges, which International Council for Commercial Arbitration's guide to the interpretation of the New York Convention.
You have made some submissions? Have you circulated? I'm just asking.
Yes, Lord.
I've circulated a note, my lords.
What's under what?
Written submission. Pallab Mongia.
The hard copies also.
Yeah.
So there's a handbook for judges.
Yes.
My lords have it, my lords? Which contains a checklist setting out the questions to be answered and the steps to be followed by courts when applying the New York Convention. In relation to Article 2.2, it lays down the following. Is the arbitration agreement evidenced in writing? Examples is the...
Mr. Babu,
Sorry.
you are reading from where? I'm not got it. It's your compilation on behalf of the intervener?
Yes. My lords, there's a compilation also. I've put the entire...
Written submit. All right.
Just to save time, I was reading from the note only which I've extracted. The relevant portion I've extracted.
Just a minute.
He is Sanjay Ghosh. Written submission.
Yes, Lord.
IA 58168. Got it.
मिला आपको?
Mila.
It's in.
Correct.
This one.
Correct.
Yes.
My lords, this is International Council for Commercial Arbitration's guide to the interpretation of the New York Convention, para 2 in my note, my lords, where they've laid down a checklist setting out questions to be answered and steps to be followed by courts when applying the New York Convention. In relation to Article 2.2, it lays down the following, and the provisions are pari materia, Section 7 and Article 2.2. Is the arbitration agreement evidenced in writing? Examples, is the arbitration agreement incorporated by reference? Has the arbitration agreement been tacitly accepted? Similar is the position in UK law also. My humble submission is that the concept is not restricted to signatories, but it's open to interpretation. And that conduct has to be inferred from anything which is evidenced in writing. That is the test. So it excludes oral agreements. Orally, one can't come to court and say, look, there was an arbitration agreement. But as long as there's something evidence in writing from where one can infer the conduct, that will fit into the description section 7 Milords.
UK law 5.
And UK law also, Milords, section 5, subsection 4, an agreement is evidence in writing. If an agreement made otherwise than in writing is recorded by one of the parties or by a third party with the authority of the parties to the agreement. So oral agreements are barred, but anything evidence in writing should be enough to infer the conduct of the parties.
Right.
And there are two instances where my lords have given liberal interpretation to the arbitration agreements. One is a Trimex judgment, which I've quoted here. Second is one Govind Rubber. It's of 2005. I'll just read the relevant parameters. It's very useful. Perusal of the aforementioned provisions would show that in order to constitute an arbitration agreement, it need not be signed by all the parties. Section 7.3 of the Act provides that the arbitration agreement shall be in writing, which is mandatory requirement. 7.4 states that the arbitration agreement shall be in writing if it is a document signed by all the parties. But the perusal of clauses B and C of section 7.4 would show that the written document which may not be signed by parties, even then it can be arbitration agreement. 7.4b provides that the arbitration agreement can be carried out from an exchange of letters, telex, telegrams, or other means of telecommunications which provide record of the agreement. So that's how the expression record of the agreement has been interpreted. It's akin to evidence in writing. That's my humble submission. And that's how the concept of implied consent is also borrowed. Para 6 I've reproduced from Gary Bond, Milords. The entire chapter is very interesting. I've reproduced the entire chapter in my compilation. Coming to section 8, Milords, interpretation of section 8. Because one of the main arguments that was made under section 8 was that there's no power vested in court under equity, and therefore equitable principles cannot apply. My response to the same is that these arguments come forth when the judicial fora or the courts are creation of that very statute. So they are bound by the powers given in that statute. But this is a case where courts are not creation of the statute or judicial authorities. They are already pre-existing under some provision. They have inherent powers. This act just gives an additional charge to those courts and say, look, you can exercise these powers also. For example, the arbitration tribunal's powers are restricted. And where they wanted arbitration tribunal not to apply principles of equity, they mentioned so in section 28.2. I have not reproduced the provision, but 28.2 clearly states that arbitration tribunal will apply principles of equity only when the parties agree so. So no such exclusion is made in section 8, Milords. Thus, section 28.2 of the Arbitration Conciliation Act states that unless the parties expressly authorize the tribunal to decide ex equo et bono or as amiable compositor, the tribunal cannot decide on the principles of equity. Alternatively, Milords, my submission is that the application of principles like lifting of the corporate veil or third parties or looking at the intent is not a concept of power. It is a concept of application of legal principle.
Okay.
For example, the lifting of the corporate veil, it's not a power vested in any particular statute like Companies Act, etc. But courts, while interpreting various statutes, resolving disputes which come before them, they apply the principles of corporate veil. For example, the Constitution Bench judgment of LIC versus Escorts. I have reproduced in para 3, B3, Milords, page 4 of my submission. This is a case which pertained to FERA. And there was no express provision, unlike the taxation statutes, which specifically provide for lifting of the corporate veil. In FERA, there was no such provision. Yet, the court was called upon to lift the corporate veil and see who's the owner. Similarly, industrial disputes also. The tribunals specifically try to find out who's the employer. And for that, if they have to lift the corporate veil, they lift the corporate veil. If I may just read this para 90 from LIC versus Escorts. It was emphasized that regard must be had to the substance and not the form of a transaction. Generally and broadly speaking, we may say that the corporate veil may be lifted where a statute itself contemplates lifting the veil, like a taxation statute, or fraud, or improper conduct is intended to be prevented, or a taxing statute or a beneficent statute is sought to be evaded, or where associated companies are inextricably connected as to be, in reality, part of one concern. It is neither necessary nor desirable to enumerate the classes of cases where lifting the veil is permissible, since that must necessarily depend on the relevant statutory or other provisions, the object sought to be achieved, the impugned conduct, the involvement of the element of public interest, the effect of parties who may be affected, etc. So statutory power is not the test. The application of principle will happen if such situations were to arise before the court.
Thank you. Then now we'll read the rest of the.
Just one last submission, Milas. I'll just take 2 minutes. Milas, what I've also done is, Milas, I straight away have page 7 of my submission. I've put in a table where US courts have applied various principles to involve third parties in arbitrations. A submission was made previously, my lords, that US courts don't recognize group of companies doctrine. But that does not mean that they don't extend their jurisdiction to non-signatories. These are various instances where they have extended jurisdiction to non-signatories, my lords. One important is, my lords, CCL number 1, Alter Ego, Shapoorji Pallonji Company Private Limited versus Other India. There's a Delhi High Court judgment where they actually analyze the US law and says that, look, these principles are applicable in Indian jurisprudence as well. May I just direct my lord's attention to the compilation. Miles may have page 172 of my compilation. Miles may have straight away para 24 and 25 on page 178. Milos, have it?
Yes.
He first quotes Gary Bond. According to Gary Bond, the principal legal basis for holding that the non-signatory be bound by an arbitration agreement is to include both purely consensual theories, example, agency, assumption, assignment, and non-consensual theories, example, estoppel, alter ego. In several cases, implied consent is used as a basis to hold that non-signatories are bound by the arbitration agreement. It is well settled that in cases where the signatory is an agent of the principal can be compelled to arbitrate, even though it is not a party to the agreement. This rests on the principle that the arbitration agreement may not have been signed by non-signatories, but was executed on its behalf. This principle is applied essentially in cases where agent-principal relationship is established between the signatory and the non-signatory, and it is established that the signatories had acted under authority of the principal. There are several cases where the courts have found the conduct of the signatory and its principal to be sufficient evidence of the relationship. And then they quote other instances where other principles apply. For example, the quotation para 26, where a party conducts itself as if it were a party to a commercial contract by playing a substantial role in negotiations and or performance of the contract, it must be held to have impliedly consented to be bound by the contract. And then they go on refer to other cases. Gary Bond is referred again, para 29. Para 31, there's an important quotation. The court observed to allow plaintiff to claim the benefit of a contract and simultaneously avoid its burdens would both disregard equity and contravene the purposes underlying enactment of the Arbitration Act. This is where the principle of equitable estoppel comes in. And in the next para 32, a non-signatory may be stopped from avoiding arbitration where it knowingly accepted the benefits of an agreement with an arbitration clause. The benefits must be direct, which is to say flowing directly from an agreement. And then they go on analyzing Dow Chemicals. I'm skipping all of that. I mean, the US Supreme Court judgment is very important, para 37, where again they apply principles of equity estoppel. And then they repeat all the MTNL cases and all. And they conclude that they need not rely upon group of companies doctrine to reach their conclusion. There are other principles which are actually taken out of principles of contract, agency, and corporate law principles and equity to reach the same conclusion. My concluding submission is, my lords, that my lords are deciding the scope of group of companies doctrine, but my lords may consider that non-signatories should not be completely ousted from because of the ruling on group of companies doctrine. There are other tools available in the statute which permit application of addition of non-signatories to that. I'm highly obliged. Mr. Chairman.
Thank you, Ms. Mongia.
It's 501.1, my lords, arises out of a section 9 petition. my lords.
That is seal number. What's your I number?
My lords, it's not an IA, my lords, it's 501.1. It's an SLP itself, my lords, which has been tagged with this matter.
SLP number?
SLP, it's SLP number 8607 of 2022. That's 501.1, my lords.
Yes.
But that is arising out of section 9, my lords, whereas the reference squarely is square section 8 and 11. So, my lords, that matter, my lords, should be detagged in my humble submission, my lords.
Your matter.
Yes, my lords, because that is specifically arising only under section 9.
My matter. I am the petitioner in the matter. I'm appearing for the petitioner, Mr. Khambata.
I appear for one of the respondents.
One of the
It's a
respondents.
little late in the day for my learned friend to get up at this stage and say, detag it.
He's appearing for respondent 1 and 2.
I do.
It's just that we are on this side of the table because the proposition that we advance is a proposition which is
All right.
distinct from the proposition.
You're
on
only
the other
seeking
side.
leave to make submissions on law before your lordship.
Yes, yes.
There would be no foray into the facts at all.
That's
All
right.
right, we'll,
Then, my lords, hear me for 5 minutes on section 9. Because, my lords, section 8 and 11.
let's hear them and then you can.
Like that. So then I'll wait for me.
All right.
Yes, thank you.
Wait, please, your lordship.
Yes, Mr. Solicitor.
Lord, I'll just, my lord, since now there is an addition of counsels, my lord, on this side, I'll also have to, my lord, compress the submission so that your lordships may at least, my lord, attempt to conclude on this today. Finalized at late night, my lord.
Why don't you mail it to us? Mail it to the court master first, or do you need to mail it to the court master? Immediately mail it to us.
I'll immediately do.
I drop it in.
Lord, I'll just, Lord, give 6 propositions. Lord, I am appearing for the Union of India. I am indeed grateful that your lordships allowed me, my lord, though I am not a party. But your lordships have 2 extreme positions. One saying that it applies completely, and one saying that it can never apply. And there is an exclusionary exclusionary statutory mechanism. That's one side of the argument. Lord, my argument will be nuanced arguments because we want this act to become effective and functional. And it does not become effective and functional if disputes are fragmented.
Yes.
Lord, 5 points, my lord. I'll just very briefly take your lordships to the history as to how, my lord, this act came to be enacted. Because, my lord, some arguments are bound to be made. They were made on this side, will be made on that side. That some jurisdictions have accepted, some jurisdictions have not accepted this doctrine. That will be the first limb. Second limb would be that in my respectful submission, the doctrine of group of companies is intrinsically inbuilt in the statute itself. And I'll attempt to show that. There is no exclusion in the statute. There is no exclusion of this doctrine. It is there. Third,
Sorry, what was the first point?
Lord, first was a general history, my lord,
Yes.
because that would give your lordships, my lord, assistance as to how to interpret, my lord, our statutory mechanism in arbitration.
All right.
Second would be, my lord, that doctrine, group of companies doctrine is intrinsically inbuilt in the statute itself.
Yes.
Third, presuming that the act excludes that doctrine or act does not at least include the doctrine. But my submission is going to be that doctrinal approach, your lordships have always evolved. Everything is not to be found in the letter of law. Your lordships infuse blood and soul by developing doctrines for interpretation of the statute as it stands. And that's how, my lord, the law evolves. Fourth, my lord, how other jurisdictions have treated doctrine of group of companies and what are the parameters, what are the contours they have relied upon. But ultimately, my lord, ultimately the bottom line of all these jurisdictions would be that your lordships may perhaps be able to lay down illustrative cases if your lordships accept the doctrine, but eventually it will be a case-specific determination if the doctrine is to be applied in our act. And last, Lord, what would be the, if your lordship, subject to what your lordship ultimately decides, whether the doctrine applies in our Indian scheme of statute or does not apply, but if it applies, what would be the contours of the court's jurisdiction under Section 8 and the jurisdiction of my lord the Chief Justice or his lordship's designate under Section 11, subsection 6? To what extent, my lord, the examination would be required at that stage?
Yes.
Yes, my lord, since my lord, there are other, my learned friends are also, my lord, I'll compress it, and what may not be directly relevant, my lord, I'll point out briefly. Lord, first of all, so far as history is concerned, your lordships are aware, whatever is relevant for the present dispute. Lord, this alternative dispute mechanism concept started in 1923 with Vienna Convention. Geneva Convention, I'm sorry, Geneva Convention, 23 and 27. But it was too broad-based mechanism, and in fact, it was not a mechanism at all, which led to eventually New York Convention. The New York Convention essentially dealt with enforcement of foreign awards. There was no mechanism provided as to how to arbitrate. What are the powers of the arbitrator? What are the rights and responsibilities of the parties? What will be the substantive law? What will be the procedural law? What will be the curial law, etc.? Nothing was in New York Convention earmarked, but 172 states, my lord, in the context of international law, 172 countries adopted the New York Convention. Lord, that a global need was found that there has to be a model infrastructure which can be adopted by the states and which can become their respective domestic statutory law. And there comes, my lord, UNICITRAL model law. United Nations, my lord, prepared a model law in 1985, amended in 2006. So there are 82 countries which have adopted the model laws, including India. But why this is necessary? Broadly speaking, globally, there are two bifurcations or two divisions. One, who have their domestic law in tune with or in conformity with UNICITRAL model law. They are broadly referred to as model law countries. And others, they go by their own domestic law. They have their own laws, may or may not be in conformity with UNICITRAL law. Even if it is in conformity, it's not because they have adopted or assented to or become a signatory. They have picked up some issues. So there are two broad classifications of the countries. Now, my lord, I come to the main issue, Lord, my respectful submission and the first submission, that this doctrine is inbuilt in the statute itself. And there is no exclusion, my lord, as argued. My lord, if I am right in reading the provision the way I read, then, my lord, we need not find anywhere else any provision for exclusion or inclusion. It is included impliedly, intrinsically. Lord, kindly, therefore, on this point, come to page 2. I have quoted, my lord, some of the provisions to, my lord, make myself, my lord, more clear. As pointed out above, the Act uses certain terms, expressions, and phrases very broadly so as to not reflect the scope of alternative dispute redressal mechanism in minimum category of cases only. By way of an example, the term international commercial arbitration as defined under section 2(1)(f) broadly takes within its wide sweep all arbitration relating to, please mark this, my lord, something would turn on this, my lord, therefore I have underlined it, dispute arising out of legal relationship, whether contractual or not. Lord, very widely worded term, any kind of relationship, if it gives rise to or give birth to a legal relationship, and irrespective whether it is contractually incorporated or not, it would become a subject matter of international commercial arbitration. So now, Lord, why I pointed out the UNICITRAL model law which we have adopted. UNICITRAL model law essentially dealt with and deals with international commercial arbitration. The respectful submission is the commercial element of any dispute or a business sense element of any dispute is implicit, it's intrinsic in our act also. Though our act is not restricted to commercial disputes, there can be other disputes as well. Now, please come to para 6. Coming to domestic arbitration, also it is clear that the group of company doctrine has remained inbuilt in the scheme of the Act before and after Law Commission's report number 246 and the amendment made in the year 2015 based thereon. Firstly, the term arbitration agreement is consciously not defined either under Section 2 or elsewhere so as to include only an agreement in conventional sense of the term as used in Indian Contract Act or elsewhere. the legislature has very consciously avoided a restrictive definition which gives a conventional meaning to the term agreement, that is, a document executed by the parties at the foot of which the parties would put their signatures. Lord, nothing prevented the legislature from saying that arbitration agreement would be between parties who will be the signatories to the arbitration agreement. The definition says this, and in my respectful submission, it reflects the legislative intent. Arbitration agreement means an agreement referred to in section 7. Am I with your lordship?
Yes.
At this stage, for the present purpose, the definition of the term parties as used in section 2H needs to be examined. Section 2H reads as under, party means a party to an arbitration agreement. So agreement is not defined. Agreement means whatever takes color of an agreement under section 7. And the party is also not defined except to say that whoever falls within 7 will be a party for the purpose of this act. On true, meaningful and purposive interpretation of the act, that is speedy, less time consuming, comprehensive, unfragmented and effective resolution of all disputes, it becomes clear that section 7 itself statutorily recognized group of companies doctrine. The key word in my respectful submission is unfragmented dispute resolution. I have a dispute with A, but B is also a part of that dispute. So don't fragment it merely by giving a restricting meaning that I will have relationship with A and therefore arbitration between me and A, but for B I have to file a suit. That's not the intent. Now please see, my lord, the definition of the arbitration agreement. Lord, I have quoted section 7. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. I would respectfully read, my lord, subsection 1 like this. Arbitration agreement is an agreement made by the parties when you can show that there is a defined relationship. It need not have contractual foundation. Then it would be an arbitration agreement. Not necessarily between A and B, not necessarily having a contract between A and B, reduced as a contract between A and B, not in the conventional sense of the term agreement as used in the Contract Act. Now, your lordships can do. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. Well, we are not concerned for this matter. 3, an arbitration agreement shall be in writing. Mr. Sibal laid emphasis on this, my lord, and read 4A with that. It will have to be in writing. And it is so. I can't dispute that. Now, please see 4A. An arbitration agreement is in writing if it is contained in a document signed by the parties. This is the first kind of arbitration agreement. This is not the only kind of arbitration agreement. If it is signed by the parties, then it is an arbitration agreement. But B, Lord, if the legislature would have stopped at 4A, possibly the restrictive meaning was possible. That it has to be signed by the parties, it should be in writing, and that document only creates a legal relationship, defined legal relationship. But please come to B. Now there is no, my lord, arbitration agreement as contemplated under 7(4)(a). An exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement. Please, my lord, mark which provide a record of the agreement. Lord, in my respect,
Record of the agreement would mean from which you can deduce the essential terms of the.
I'm obliged, my lords. I could not have put it that succinctly. My respectful submission is the record of the agreement means any act of agreeing to certain things, not agreement in the conventional sense. So, my lord, if there is an exchange of correspondence between A, B, and C, the contract may be between A and B, but the correspondence reflects that C also understood the contract to mean that he will also perform some part of the contract. And I'll show, my lord, how such instances have happened. I'll show very, very briefly. But suppose back-to-back contracts, that during the correspondence between us, I say that I'll supply to Mr. Khambhata and Mr. Khambhata will in turn supply to Mr. Nakul Dev. The arbitration may be between the two, the agreement between the two of them. But during the correspondence, it comes out that I have also agreed to certain things to be done in a certain way. Then, my lord, merely because I am not a party to the arbitration agreement or arbitration clause, if it is a separate agreement, but I cannot say that now I can't be joined in your. Otherwise, my lord, the legislature would have used a very simple language. Arbitration agreement means an agreement between the parties to the dispute. And the parties would mean signatories to the agreement.
Yes.
So, my lord, my respectful submission is the term parties are not used in the same sense as we understand signatories. You can be a party without being a signatory to an arbitration agreement or a substantive agreement which contains an arbitration clause. Now, my lord, kindly see page 4, para, at the foot, para 11. The concept of business prudence ingrained in section 2(1)(f) for international commercial arbitration is again inbuilt and ingrained in section 7. Section 7 neither restricts the term agreement to be one conventional document nor restricts it either document-wise or party-wise. It uses a broad expression defined relationship, whether contractual or not. This is clearly suggestive of the legislative intent that any kind of legal relationship, even if it is not contractual, that is, there is no contract between the entity, my lord. I am not using the word party or signatory. Between the entity whose actions or participation results in a defined relationship can form the subject matter of an arbitration agreement. That's why this wide definition consciously chosen. 12, my lord, I have already pointed out. 13. Section 7(4) mandates an arbitration agreement to be in writing. The conventional agreement which comes to one's mind, that is a written document describing inter se rights and liabilities between the signatories to the document, bearing the signature of such contracting parties in such agreement, is placed in section 7(4)(a) as a separate and distinct category. Now, next, the said agreement contemplated under 7(4)(a) is, however, not restrictive, but will be guided by 7(1). So, my lord, there can be, my lord, kindly pause here for a minute. There can be an agreement which is under 4(a), document signed by the parties. I'm sorry, 7(4)(a), which is a document signed by the parties, but it will have to be examined under 7(1), because if it can be an agreement where it clearly comes out a defined relationship which may not be contractual under this agreement. Lord, I hope, my lord, I am able to make myself clear. My lord, continuously, my lord, I am saying, my lord, in their contract, Mr. Khambhata and Mr. Devan's contract, they continuously refer that the goods will be supplied by Mr. Mehta. I am not, my lord, a document signed by the parties. I am not a signatory to that document. But from the document, it emerges that there is a defined legal relationship emerging from that document. Like, for example, there are certain obligations incorporated by reference. They can say, Mr. Khambata can say that I'll supply goods to Mr. Devan, but we have a separate agreement dated so-and-so, registered at so-and-so with Mr. Mehta. And he has agreed thereby that he would supply the similar goods to me, which I will supply to him. So
You may not have bargained for a contractual relationship between you and Mr. Diwan, in your example.
Yes.
Unless there is a tacit acceptance by you of the obligation which Mr. Khambata has assumed to supply goods to Mr. Diwan, you would not be liable.
No,
Merely because, say, suppose, for instance, you are the foreign collaborator of Mr. Khambata's client, all right, that you are the person who has prepared the software, or you have prepared the service agreement, the license agreement, you are the real originator of it all. Unless there is something to indicate that, look, you have assumed the obligation, or that you stand behind the obligation which Mr. Khambata has assumed to.
I vowed. That is why I emphasize it must emerge a defined legal relationship with respect to the dispute. I'll just give an example, simpler example. Look, Tata Steel is a Tata group of companies.
Yes.
Tata Motors is a Tata group of companies. Suppose Tata Motors enters into an agreement with me for buying certain products, tires, machinery, etc., etc. And there is a dispute between the two of us. I can't involve Tata Steel saying that it's a group of companies. If he is unable to pay, you pay. But if there is a defined legal relationship with third person, and that is how, my lord, the courts have construed. Defined legal relationships are presumed under various doctrines which your lordships have evolved in other jurisdictions also. Back-to-back contract is one such thing. It would be a fact-specific determination.
Right.
There would not be any, my lord, straight-jacket answer. But the point I am respectfully urging for your lordship's consideration is there is no exclusion. In fact, Section 7 incorporates group of company doctrines by not restricting it to mere parties to the agreement, except in 4.1a, 7.4a, but it restricts even correspondence. There can be a correspondence that, all right, we supply, they supply, etc., etc. Lord, now kindly come to page 10. It is thus clear that even if there is a contractual document in existence between party A and B, as contemplated under section 7.4, I'm sorry, page 6, page 6. It is thus clear that even if there is a contractual document in existence between party A and party B, as contemplated under section 7.4a, if both of them have a defined legal relationship with entity C or D, qua the dispute, not, my lord, some other relationship. I am now, my lord, restricting to give a purposive meaning, my lord, and to ensure that it doesn't become an unruly horse where anybody and everybody is included. Qua the dispute, an arbitration would take place amongst A, B, C, and D, irrespective of as to whether A, B, C, or D are contractually connected with each other, or irrespective of whether C or D are signatories to the document contemplated under section 7.4a. Well, this is the crux. So parties are not to be read as synonymous of signatories, and the existence of a defined relationship, legal relationship, can be inferred from the correspondence also. Lord, kindly come to, ignore 14, come to 15. Lord. Section 7.4b, however, makes above referred legislative intent more clear. It specifically does away with mandatory existence of a conventional document only to be regarded as an arbitration agreement. Under the scheme of 2H and 7, even exchange of letters, telex, so and so, is an arbitration agreement if it provides record of agreement based upon a legal relationship. Now, my lord, next is relevant, as my lord very succinctly, my lord, fell from my lord the Chief Justice of India, the subpara.
Yes.
In other words, the term agreement, except as used in section 7(4)(a), that is document signed by the parties, is used not in the conventional sense of a document of agreement with signatories, but as an act of agreeing. This is, my lord, the heart and soul of section 7. Whether contractual, not contractual, if it gives rise to a defined legal relationship and there is a reflection of some act by even non-signatory agreeing to something by each and every mode, whether contractual or not, and may be between more parties, if all of them constitute a legal relationship in a transaction. This is how, my lord, the letter of section 7 will be infused with spirit and blood by your lordships by interpretation.
Now, Mr. Mehta,
My lords.
see, the contract, the correspondence between A and B, and what they decide is, it is the C who will supply. But C is not a signatory, the example that you have taken. Now, unless there is a conduct in furtherance of the contract between A and B by C, you can't rope in C. There has to be a conduct,
Your lordships are right.
and the conduct is in furtherance of the contract between A and B, although C is not a signatory. So therefore, just the correspondence between A and B will not drag in C under the group of.
I bow down. Your lordships are right. My lord, the example which I would wish to give to buttress my argument would be this. What is essential is something should emerge to be a defined legal relationship. Number one. Number two, it need not be a document signed by two parties as an agreement. It can be exchange of letters. Now, in the same example which my lords were pleased to give, not suppose there is a correspondence between A, B, C, A to C, C to B, B to A. And if it can be found out that because of this correspondence, though the arbitration clause is only between A and B, but C has also participated. He was a part of the negotiation process. He also given certain assurances, etc. Then C cannot say that I am not a signatory to the contract between A and B, and therefore I cannot be a part.
Therefore, in this example, really speaking, there's a predefined relationship, pre-existing relationship between A and C when A agreed to.
Or B and C for that matter.
Yeah. A, B, and C, Mr. You are A or you are C. Mr. Khambata is A and Mr. Diwan is B.
Correct.
So when A agreed to supply goods to B, and there is obviously in your example, there is exchange of correspondence, there is an exchange of emails, there is an exchange of communication between C and A and B, and by which C also is intrinsically a part of either the negotiations or the performance or the execution of the contract. These cases may not be that difficult. Question will arise where C has completely stood separately and away from the contract.
Bystander.
He's a bystander. But there is a pre-existing relationship between A and C, which is what you, I'll just go back to your, the way you have formulated it at page 7. A, an agreement, arbitration agreement as understood under the Act is not a conventional agreement only. Fair enough. An arbitration agreement can take place whenever certain disputes arise among entities when such entities have a defined legal relationship.
That is must.
That is your relationship with C's relationship with A. Then C.
No, with the dispute.
With the dispute.
No, not with the parties. Existence of a defined legal relationship
with the dispute.
With the contract, I would say, qua the contract.
we'll add in B then, have a defined legal relationship with the dispute or the contract.
Or contract. I may not be a signatory to the contract, but I have from the exchange of correspondence by some action. For example, my lord,
So long as we say quay the contract, I think then it becomes a little more structured. Once we
yes.
add quay the contract.
Correct, my lord. My lord, for example, there is a tender floated by Mr. Diwan, and my learned friend Mr. Khambata is participating, where there is a requirement that some company having more than 500 crores turnover will stand as a guarantor so that he can supply the goods to him. I am that company. I stand as a guarantor, and there is an exchange of correspondence. Then it will be, my lord, a fact-specific determination. But I cannot say that because I am not a signatory to your contract, I am out of it. If there is a defined legal relationship emerging from our actions, because therefore the legislature says contractual or not, there can be a defined relationship without entering into a formal contract.
So how does this relationship come in? By your agreeing to be the guarantor in the contract between A and B. So therefore you have entered into, or you have acted in a manner which has furthered the contract. So you can't be saying that I am a bystander there. In that,
Therefore, you can't be saying in that case that, look, I'm not a formal party to the arbitration agreement, which was a contract between A and B, which contains the arbitration agreement.
For example, there
But
is a...
ultimately, Mr. Mehta, therefore, it boils down to how you will interpret that particular fact situation.
Exactly. It will
So
have
really, you should not be laying down
fact-specific determination.
You should not be laying down extremely rigid or tightly controlled.
Cannot be and should not be. That's my respectful support.
So then it will be very dangerous.
Yes, well, that cannot be, and that's what I have said, that it will have to be a fact-specific determination. Suppose a Chinese company has a local Indian company as its subsidiary and is entering into contract with local Indian other companies or other individuals, and the Chinese company agree that yes, we are behind it, we are a financially sound company, you can enter into this relationship, and there is an exchange of correspondence, which gives rise to a defined legal relationship. Its relationship is not that of a mortgage, that of a guarantor. The legislature doesn't use a particular kind of defined legal relationship. Any defined legal relationship,
whether contractual or not.
Contractual or not. So that's not my respectful submission. Lord, para 18, Lord, your lordships need not read, I'll just orally point out. Your lordships were shown that
what would be examples of non-contractual legal relationships?
My lord, non-contractual, I have given, my lord, some of the examples. There are several theories, my lord, which have emerged in other jurisdictions. My lord, for example, back-to-back contracts. My lord, they have a contract. They have to have a contract. I am not a signatory. I am not bound by any defined legal relationship. But I have a back-to-back contract with him. And the facts suggest that I'll supply to him, which he will in turn supply to. So technically, there is no contractual relationship so far as I am concerned. As far as Law Commission's report is concerned, what your lordships have seen. I'm sorry, the report. Good. Law Commission
B and A materializes and B ultimately supplies the goods to C. Transaction, C is not at all aware what is going on between. One fine day, problems crop up. What do you intend to do? B says, I have taken up the issue with A. I have nothing, how am I concerned? Can C drag A into the
Cannot. And the reason is simple. There is no defined legal relationship which came into
So
existence. But
therefore, one or two instances, Mr. Kambata may also assist us. What could be a good example of a non-contractual legal relationship?
therefore, my lord, in this very example, my lord, I'll point out. C wants some goods, my lord, and he believes that B will be able to supply it. Now, there is an exchange of correspondence between them that I want this description of goods.
You may develop it a little that in this confusion, there may be some correspondence between A and C at a
And
later point.
exactly, I'm coming to that. I'm coming.
Perhaps C may be able to drag A.
Correct. Exactly, that's what, my lord, in the example which your lordships have given, there does not come into existence any defined legal relationship between C and A. So this doctrine cannot apply. But when C approaches B, that I want this particular description of goods, and only A will be able to supply because this category of goods or description of goods only he manufactures. You are the retailer or a wholesaler. B approaches A, and there is an exchange of correspondence between three of them. A says, yes, I am agreeable if you enter into a contract as per this schedule of distribution or this schedule of supply. I will be able to supply every month 300 units, and I assure C that I'll supply it to B. Whatever is your financial arrangement, you have your financial arrangement. I can only say that I'll be able to supply. Now, a defined legal relationship comes into existence. He is not just a bystander, as my Lord Justice Roy, my Lord, very rightly, my Lord, coins the word. He is a party to the negotiation. The very fulcrum of the contract is based on his agreement. He is not a signatory in the contract between B and C. But if a dispute arises because of his failure of supply, then he can't run away from the responsibility only on the ground that he is not a signatory to B and C. That's, my lord, the contours of the document.
So again, a fact situation.
It will be very dangerous to set out all the circumstances.
It should not be.
In fact,
Should not.
The constitution bench should not even attempt to do
No,
that,
no, no.
because we must respect the wisdom of the courts concerned.
Fact situation might differ.
Particularly in commercial matters, you must leave a certain degree of flexibility for courts to,
There are two or three things, my lord, why in my
modulate their decisions based on the situation, unless there's something really positively erroneous in the doctrine. Because ultimately you have to evolve the doctrine based on, the facts as they will emerge before succeeding benches.
No, therefore, my ultimate, the fulcrum of my argument is that your lordships would decide whether this doctrine is excluded from Indian law, and if not, whether the doctrine is applicable, and the fact situation in each case to be decided, my lord, either at the stage of section 8 or at the stage of section 11 or maybe at the stage of section 16. Somebody may raise a dispute, my lord. Section 11 comes when there is no agreement between the parties and we have to approach the Honorable Chief Justice or his lordship's designate. But suppose there is a dispute between the two of us, we jointly go before an arbitral tribunal, joining C also. He can raise all these issues.
Actually, Mr. Solicitor, the last few words of section 7(1), which may have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. These words define what is the origin of the dispute, or what is the source of the dispute? The dispute, there has to be an arbitration agreement. An arbitration agreement is an agreement to submit disputes which have already arisen or which may arise in future. There's no dispute today, or which may arise in future.
But existence of relationship.
But which may arise between them and in respect of a defined legal relationship, whether contractual or not. So these words, in respect of a defined legal relationship, whether contractual or not, refer to the source
Of dispute
the
or
source
the
of the
contract.
The dispute must arise either through a contract, or it may arise through a legal relationship other than a contract.
Yeah.
So, for instance, I'll give you an example. It may sound a little, I just concocted it here. Suppose a builder has a large tract of land. He carves out plots and assigns plot A to A, plot B to B, plot C to C, plot D to D, plot E to E. Now, there is no contractual relationship between A, B, C, D, and D.
Correct.
Right?
Complete
So
bystanders.
the contractual relationship is only between A and the builder and A, the builder and B, the builder and C. But suppose in future a dispute arises between the individual purchasers over the sharing of common amenities or the sharing of a common source of water or a green area, so on and so forth. There might be then an arbitration agreement which says that any dispute between them, A, B, C, D, and E, will be arbitrable. Because then there is no contractual relationship between A, B, C, D, and E unless they've entered into a cooperative society or a condominium. But by virtue of the fact that they are neighbors, there is an element of a legal relationship, what you shall do and what you will not do to a neighbor. Okay, so therefore that is a sort of a dispute which may be an arbitrable dispute in the future. There's no contractual.
But
The
in this,
definition, section 7 doesn't talk about arbitration contract. So it is talking about arbitration agreement. Agreement is defined under the Contract Act, where there is an offer and an acceptance. Contract is defined as an agreement which is enforceable in law. So there are two legal relationships. One is a legal relationship of a contract, another one is a legal relationship of an agreement. Contract Act contemplates entire regime with respect to how to enforce a contract and also how to enforce an agreement. So far as agreements are concerned, 68 onwards talk about certain relationships resembling those created by contracts. So therefore, those aspects which have not emerged into contracts can also be subject matter of an arbitration. So therefore, it's a holistic.
yes,
An arbitration can be with respect to enforcement of contracts. It can be with respect to, that is more or less similar to specific performances.
correct.
So which is also, though it's not a contract, nevertheless, it has come within the fold of an arbitration agreement. That is how it takes within.
Yes,
the suite
now
of it.
apropos,
To take it little further, what Arbitration Act is talking about when it's speaking under section 7 of arbitration agreement, there are three inviolables there. First and foremostly, written agreement is necessary, not contract, written agreement. Second is parties are necessary, but these two are not frozen. 4B gives meaning to it, saying parties as well as legal relationship is inferable from what is defined as the record of agreement. So
not
we have
agreement in writing, but record.
What the court does is, court has in every case look into the existence of parties. That's also inferable from the record of agreement. Court will also have to see the legal relationship, which is also inferable from the record of agreement. So we will have actually a written agreement, not in terms specified as A and
act
B.
of agreeing.
A and B, but whether A, B, C, or D are inferable from the record of the agreement. And similarly, the relationship is also inferable from the record of agreement. So really speaking, coming to the question, what is
What
the
are we
constitution
deciding?
bench supposed to do? It's already there. Why this
But
reference?
the argument was
We can
that
perhaps
the
discharge the
doctrine,
reference.
the argument was that there is an exclusion of the doctrine.
There's no,
Doesn't-
there's no
Where
specific
is the
subject to
judgment
hearing,
which is
Mr. Rai.
staring in our face?
Lord, another thing. Lord,
There's no
apropos, my
specific
lord,
exclusion, as you rightly said.
Lord, apropos, my lord Justice, my lord. the-
I'll give you another example of a legal relationship which was not contractual, which can be subjected to arbitration. Suppose there are 5 brothers and sisters. They have a common property. They want a partition of the property. They want their shares to be identified, or the shares are given in law, but they want a division by metes and bounds. There's so many arbitrations which take place. There is no relation, there's no contractual relationship between the members of a family. If they are partners, there's a contractual relationship.
So, Lord,
Because then there's a partnership
your
agreement.
lordships are.
Have a- But if there is a non-partnership dispute between, say, members of a family, you can submit that dispute to arbitration. What is excluded, of course, is just that, just as Ravindran said, where it's, in rem, then you can't.
That's correct.
So you can't, it's a will.
In
So
the,
the will operates in rem. Once will is probated, probate can't be referred to arbitration.
it's in rent.
Or, that's right. Or something which is determinative of legal status, like the paternity of a child. That you can't refer to arbitration. As just Ravindran carved out, admiralty.
1, 2, 3, my lord, 3 areas are out of. Lord, now, apropos, my lord, your lordship, my lord, the.
Therefore, when you agree to an arbitration, the dispute may not emanate from a contract at all. It may emanate entirely from an area other than a contract. That's right.
Look, kindly, my lord, taste your lordship's example, my lord, again for 7-1. Again for 7-1, my lord. Kindly, I'm sorry. My lord, Justice Narasimha.
Nothing, sorry. You go
No,
ahead.
no, I'll do that.
Yes, Mr. Mehta. So,
Yes, Lord, taking your lordship's example, just my lord, then I'll move on to the other point. Lord, kindly see 7-1 in a scenario which my lord, the Chief Justice of India. Matter of fact, discovery, chair and etc. Your lordships have examined the fact specific situations. In fact, it never required a reference. I'll assist your lordship. Kindly come to 7-1 again, my lord, in the context of your lordship's my lord, illustration that a builder having a separate agreement contract with A, with separate with B, separate with C, and some dispute between A, B, C, D. Now, please see, it is in this part, arbitration agreement means an agreement by the parties. So, builder can't be roped in unless there is something to suggest that he also has acquired certain responsibilities.
way that dispute, or the way the
And it should be resulting into some kind of a defined legal relationship, which may be contractual, which may not be contractual, which may be, my lord, arising in case of, my lord, illustration like this nature, my lord, easement. Whatever, my lord, I'm not giving examples. My lord, now I'll move forward. Lord, there was a reference that there is a Law Commission's report, Lord, 246th Law Commission report. I'll finish it in 5 minutes, this Law Commission report one. Lord, there was a suggestion. There were 2 suggestions. Lord, page 7. A. The Law Commission merely recommended amendment to section 21H, that is parties, and not to section 7 of the Act. In other words, even the Law Commission did not find that without amending both section 21H and 7, group of companies doctrine cannot be statutorily recognized. They never said that you amend section 7. B. The said definition was not required to be mandated as the suggested definition. If read, my lord, your lordships can skip, my lord, I have reproduced and possibly somebody has read, my lord, 61 to 64 of Law Commission's report before your lordship. But C, when section 7 provides for a permissible dispute resolution, even amongst the third party, even if they are not contractually bound with each other, mere enlarging the scope of the term party to add person claiming through or under such party, that was the amendment suggested, may perhaps restrict the wider meaning of section 7. And therefore, my lord, maybe that is not accepted. Lord, I hope, Lord, I am able to make myself clear. Section 7 is very widely worded so as to include every kind of legal relationship if there is an agreement shown to exist, whether agreement is contractual, not contractual, irrespective of that. Now, if the definition of section 2(1)(h) is amended, it would restrict that either person claiming through him. So possibly that can be the reason it was not, my lord, amended. The officer of the law ministry is here, my lord, with the record. I don't want your lordship to see, but if your lordship wishes, I can place it, my lord, and your lordships can see them. I can show it to others.
Is there anything specific in that?
Lord, the only thing is, my lord, that there is a table. The Law Commission suggested several amendments. Left-hand side column mentions the suggested amendment. Right-hand side column mentions the response of the law ministry. On 2(1)(h), they say should be accepted. But thereafter, it never materialized when a bill was prepared, which became an act in 2015, the Amendment Act. So that is.
So it was accepted in the law ministry, but it
didn't materialize. And there is nothing on record we have checked up to show why that happened, whether inadvertence, a conscious decision.
Drawn up in the pool.
To explain that restrictive meaning was avoided.
Yes.
They wanted to keep the expression enough to take into account all kind of possibility scenarios.
As contemplated under 7.
As contemplated under 7.
Otherwise,
that 7 is wide enough to take.
2(1)(h) as suggested to be amended may perhaps restrict 7. Because then it would be parties. Party would mean either party himself or someone claiming through him. Then, even if there is a defined legal relationship emerging, even if an act of agreeing, without there being any formal agreement emerging.
But the notes in the ministry do not suggest that consciously such a decision with this intent.
It is not. I must frankly, my lord, admit
it was just not gone through. Although recommended.
Didn't go through, my lord. That's all. But I'll place, my lord, the file for your lordship's consideration. Lord, section 8, I don't wish to, my lord, dwell much. It merely gives an additional locus. Earlier, my lord, what used to happen, if contracting parties are before a civil court or any judicial forum, only the party can say that send us to arbitration or send them to arbitration. Now, my lord, even any other person claiming through or under him also can do it. It gives additional locus in section 8, nothing beyond it. My lord, it doesn't affect the applicability or otherwise of the group of companies doctrine.
Yes.
Lord, page 10, para 22, my lord, the heading, my lord, I'll not, my lord, dwell much, but my lord, I'll just orally point out in 2 sentences that the very object of the act is to ensure that dispute A is resolved fast. This second, it is not fragmented. If someone is really a part of a defined legal relationship, then I'll fight with A in an arbitration and I'll fight with C in a civil suit. That is avoided. So your lordships would avoid a meaning which defeats perhaps the intention of the legislature. Lord, now page 11. Lord, your lordships may not again read it. I'll just orally point out what my submission is. May I read, my lord? Or
yes. Page 11.
11, para 28. Lord, the submission is that every jurisprudential doctrine may not have its foundation or basis in a statute. Lord, Lord, without reading it, I'll just orally point out what my respectful submission is. Lord, the legislature provides the letter of law
Yes.
And your lordships, by judicial interpretation, infuse the spirit and blood in it. And that is, my lord, the doctrinal approach. Lord, for example, doctrine of estoppel, the doctrine of legitimate expectation, nowhere to be found in any statute.
Promissory estoppel.
Promissory estoppel, my lord. There are, my lord, the doctrine of piercing corporate veil. It's not part of any statute. Doctrine of proportionality. It's not a part of any statute that it has the punishment or act should be proportionate to what is being dealt with. Then doctrine of causes omissus. So, my lord, jurisprudence evolves once the letter of the law is interpreted by your lordships and your lordships infuses blood and soul in that letter of law provided. If it defeats the very intention of the act, my lord, it cannot be accepted. Suppose there would have been a doctrine in the arbitration context which would have defeated the very object of the act. Then your lordships may, in a 5-judge combination, say that no, this doctrine is not applicable. But it furthers, my lord, the object of the act. It supplements the intention of the legislature. So now the question is, when there is statute silence in the statute law, can the doctrinal approach be incorporated while dealing with that law? So to put it differently, when this was an argument that when there is no reference to group of companies doctrine, can you read that into Section 7 or any other provision merely as a doctrine which is evolved by judicial interpretation? Lord, there is a recent judgment of the United States, my lord, United States Supreme Court, my lord, and allow me to read that page 30 in arbitration. In arbitration, my lord. Lord, therefore, my lord, before I read it, my lord, please examine. There are several countries broadly classified as those who have adopted the model law of UNCITRAL, those who have not adopted the model law of UNCITRAL, but all have their domestic laws, maybe fully in conformity with UNICITRAL, maybe partly in conformity with UNICITRAL, maybe completely different from UNICITRAL. Whether they can use the doctrinal approach or not, as per their domestic policy. Suppose India is UNICITRAL compliant law. Can we not have some doctrine? Lord, that is answered by the Supreme Court of United States at page 13. Lord, the citation I have given, my lord, and I have placed, my lord, the judgment also, my lord, GE Energy Power Conversion Finance. My lord, para 13, my lord, may I read this judgment, my lord? This silence is dispositive here because nothing in the text of the convention could be read to otherwise prohibit the application of domestic equitable estoppel doctrine. Now, please mark it. Equitable estoppel doctrine is a facet of group of companies doctrine. I'll show. Equitable estoppel doctrines. Because I will be stopped from saying something which I did, which resulted into a defined legal relationship. Only one article of the convention addresses arbitration agreements, Article 2, and only one provision of Article 2 addresses the enforcement of those agreements. Article 2.3, the text of Article 2.3 states that courts of a contracting state, like India, but India would be a contracting state in this context, shall refer the parties to arbitration when the parties to an action entered into a written agreement to attribute and one of the parties requests referral to arbitration. The provision, however, does not restrict contracting states from applying domestic law to refer parties to arbitration in other circumstances. That is, Article 2.3 provides that arbitration agreements must be enforced in certain circumstances, but it does not prevent the application of domestic laws that are more generous in enforcing arbitration agreements. Now, please mark this, my lord. Article 2.3, that is UNICITRAL, contains no exclusionary language. It does not state that arbitration agreements shall be enforced only in the identified circumstances. Given that the convention was drafted against the backdrop of domestic law, it would be unnatural to read Article 22(3) to displace domestic doctrines in the absence of exclusionary clause. There has to be a statutory provision excluding the doctrine. In absence, doctrinal approach will be available to the courts while interpreting the arbitration agreement. This interpretation is especially appropriate in the context of Article 2. Far from displacing domestic law, the provision of Article 2 contemplates the use of domestic doctrines to fill the gaps in the convention. For example, Article 2(1) refers to disputes capable of settlement by arbitration, but it does not identify what disputes are arbitrable, leaving that matter to domestic law. Then, my lord, some judgment is cited. Similarly, Article 2(3) states that it does not apply fails to define those terms. Again, the convention requires courts to rely on domestic law to fill the gaps. It does not set out a comprehensive regime that displaces domestic law. In sum, the only provision of the convention that addresses, dear lordships, can, my lord, 14. In sum, the only provision of the convention that addresses the enforcement of arbitration agreement is Article 2(3). We do not read the non-exclusive language of that provision to set a ceiling that tacitly precludes the use of domestic law to enforce arbitration agreement. But here one can read, my lord, doctrine. There is no exclusion by the statute. Statute could have excluded. Statute could have excluded, subject to, Lord, meeting with your lordship's test if challenged. Lord, New York Convention, my lord, I have addressed your lordships. My lord, I will not take your lordships to, my lord, that. Kindly come to page 17 directly, my lords. Some of the parameters which are considered, my lord, we have examined for your lordship's assistance. And, my lord, it would be your lordship's pleasure, my lord, whether I go into this in detail or not. I may not go to, if your lordship, my lord, feel that it might unnecessarily consume time. But the exercise is this. What are the parameters considered by other jurisdictions of the world to incorporate, to accept the group of the company doctrine? It's not just a group of the company, that somebody is a company and is group company of somebody else. That's not the only thing. Lord, please come to, my lord, page 19. Representation, agency and apparent authority. Often theories of agency and these are illustrative. These are not exhaustive. It would depend upon the fact-specific situation. Often theories of agency and representation are relied upon to bring an arbitration claim against a party who is not signatory or a part of an arbitration clause. Though the exact meaning of the agency and representation is different in each jurisdiction, the fundamental principle is that one party, acting as an agent, execute a contract on behalf of other party, which will be the principal. Then irrespective of who the signatories are, both are liable. In this kind of scenario, questions have arisen as to whether the principal authorized the agent with categorical power to enter into and bind the principal in the arbitration clause, or the power so conferred was general authority to enter into a contract which is a substantive contract. But most of the case law is on this, that I authorize my agent to enter into a contract, but my authority can be specific. That, all right, you bind me even for arbitration, or my authority may be limited, that bind me in the main substance of the contract. If there is a dispute, two of you settle. That would be fact specific. Variety of situations have arisen under this head. If from the agreement, whether an agreement in conventional sense or an act of agreeing through correspondence or other acts, expressly confers power on the agent to bind the principal, even with regard to the arbitration generally, the doctrine is made applicable and the principal is joined in arbitration proceeding and is bound by its outcome. Now, my lord, some jurisdictions have gone a step further. There may not be any express authority, but a presumed or ostensible authority. Somebody, my lord, gives an impression that I am authorized and the principal doesn't object by his act of commission or omission. Please see, my lord, absence of actual authority in some jurisdictions, the courts are also examining whether a party not mentioned in the arbitration clause should still be bound on the basis of apparent or ostensible authority of the party which is a party to the clause or substantive contract. In the event of a party initiating arbitration against a non-signatory or a non-party, the claimant will have to satisfy two conditions. But these are the broad conditions, my lord, which are generally found in all jurisdictions when it's a question of fastening the responsibility based on ostensible authority. A, the principal had very apparently induced by way of a false representation the claimant to believe that the agent had the authority to bind it in an arbitration clause. B, such misrepresentation can also be implied based on the existence of undeniable and intricate business and corporate links between an ostensible principal and or the ostensible agency, which can reasonably lead the claimant to believe the existence of such an authority. This will again be a subject matter of fact situation in each case. Lord, I can skip, Lord, others. Kindly come to third party beneficiary. Lord, some jurisdictions, my lord, to how far, my lord, this court would accept again would depend upon the fact situation. But if in a contract between A and B, it is explicitly mentioned that it is for the benefit of C, and C has derived some advantage under the contract, he cannot take the plea that he is not a signatory and therefore would not be bound in the arbitration. Then party taking direct benefit. Now, I have given some judgments also. Lord, I don't think, my lord, I should read those judgments, but this is for your lordship's assistance. And we have placed, my lord, the copies of the judgment, my lord, if your lordship considers it at your lordship's, my lord, leisure to read. Then, my lord, incorporation by reference. My lord, I am not reading it. I'll just generally give the overview, my lord. There are judgments, my lord, which I have cited in the footnote. My lord, in some jurisdictions, what happens is a contract is between A and B. C is completely alien to the contract. But the contract refers that for the performance of the contract by A with regard to B, C has, by later dated so-and-so, agreed to do this. C has, by act, supplied something. C has, by his act, purchased something. So, my lord, in fact situation like this, incorporation of responsibility even by implication or reference made in the agreement with regard to a party who is not a signatory to the argument, that is also, my lord, accepted, and that is also, my lord, an extended group of company doctrine. Then your lordships may come to 24, doctrine of single economic entity. My lord, the case of discovery which my lords decide, where the registered office of the company and the subsidiary was on the same place, the chartered accountant was same, several things were being done together, one was representing other and other was representing one, my lord, respectively, etc. Then, my lord, parameters, my lord, which are, my lord, if your lordships can quickly go through 24 bottom. My lord, these are examples. Basically, my lord, as I say, my lord, these are illustrative lists, cannot be an exhaustive list, my lord. But there are several, my lord, illustrations I have given. Then, my lord, since I am not wasting their time, my lord, I am not going into it. Equitable estoppel doctrine, single employer liability, controlled group. Lord, there are several facts which emerges before your lordships. That this is controlled by this group. This is just money going from right pocket to left pocket. Then also, my lord, it has done. Then economic realities tests. There are some judgments, my lord, on that, where group of company doctrine is applied, joint employer doctrine, etc.
Yes.
Now, my lord, what would be last, my lord, my submission? What would be the contours? My lord, suppose your lordships were to hold that as a doctrine, group of company doctrine is accepted. At the stage of section 8 or at the stage of section 11, what extent your lordship's examination would be? Lord, earlier there was a 7-judge bench judgment, that is, my Lord, SBP and Company versus Patel Engineering Limited, page 32, my Lord, and I have quoted.
Yes.
I'm not reading it for a reason which will come subsequently, my Lord. My Lord, here it was, my Lord, pre-amended situation. My Lord, kindly, my Lord, take this a little, my Lord, kindly consider this. Lord, prior to the amendment, my Lord, the Chief Justice of His Lordship's designate under Section 11(6) was supposed to look at only the existence of arbitration clause, nothing beyond that. This judgment of the 7 honorable judges of this court was based on the earlier law. Thereafter, the law changed. And, Lord, a little wider jurisdiction, my Lord, now is available with the Honorable Chief Justice or His Lordship's designate Lordship. Now, kindly come to para 35. After that, my Lord, Vidya Rolia comes. And it says that now, in view of the amendment in the Act, namely Section 11(6), this Patel Engineering is not an applicable law. It could not have said good law. It's not an applicable law because of the change of law. And, my Lord, this judgment, my Lord, subject to, my Lord, being pointed out contrary to this, my Lord, holds the field today. And I don't think, my Lord, there is anything which can be objected to. This is the test laid down. Lord, it's a 3 honorable judges. Justice Khanna wrote, Lord, the majority view, and then the Honorable Chief Justice, Lord, wrote a concurring supporting. May I read, my Lord, or leave it at that?
That's okay. I think we can.
Yeah.
Lord, I have also, Lord, given that, my Lord, and, my Lord, I have also said that apart from Section 8 and Section 11, another stage is Section 60, where, my Lord, this issue can be raised and can be considered. The only last argument, my Lord, which is not a part of my written submissions, but in the morning, my Lord, I could think of it. Please come to Section 28, my Lord, and I'm done. I'm not referring, my Lord, I'm not, my Lord, repeating anything. 28. Lord, the group of companies doctrine has its root in equity, because your lordships do not desire multiplicity of litigation and one-stroke dispute resolution solution under the arbitration clause. And your lordships can evolve that doctrine, that's the submission, rules applicable to substance of dispute. Lord, please see 2. The arbitral tribunal shall decide ex equo et bono or as amiable compositor only if the parties have expressly authorized. Meaning thereby, this restriction that you cannot have any doctrinal approach is not restricting arbitral tribunal's jurisdiction, not your lordship's jurisdiction. Your lordships can say that this doctrine is the doctrine which is in furtherance of the intent of the Act. And 3, while deciding and making an award, the arbitral tribunal shall, in all cases, take into account the terms of the contract and trade usages applicable. Your lordships are also, my Lord, while applying doctrinal approach, not bound by the terms of the contract.
Suppose we say that the arbitrator shall decide.
Then
what happens?
No, my Lord. Then also, kindly see me. He will go by, my Lord, the trade, Lord, 3, trade usage. That yes, in this particular trade, this is perfectly usual. Lord, really speaking, the tribunal would decide that issue, not under 28, but under 16. Under 16, whether there is an arbitration, whether we have the jurisdiction on the arbitral tribunal's jurisdiction. Here, the tribunal would be bound by a lordship's doctrine, because that's the judicially evolved doctrine, and not bound by the terms of the contract. Lord, these are my respectful submissions.
Thank you, Mr. Solicitor.
Lord, I have given, Lord, the judgments And my lord, some potential which we found, my lord, to be useful and my lord, assisting your lordships, which is already filed. I'm not reading it. Your lordships can, my lord, if your lordship feels, just glance through it. It would, my lord, assist the court, my lord, in arriving at it.
Thank you, Mr. Solicitor.
My lord, immensely grateful, my lord, for the input. My lord, would your lordship, my lord, I'll just place, my lord, that file,
Sorry,
the file of the law ministry, your lordship,
not necessary, I think.
to them and thereafter.
Not necessary.
Please, your lordship.
Will be adopting the same line as the solicitor or?
Not exactly, my lord. I'll tell my lord broadly the line I'm adopting.
Your lordships can pardon my absence for some time. Right?
Now, Mr. Kambata is going to argue, then Mr. Ritin Rai, right?
Yes.
That concludes everybody.
Mr. Devan is, I think, also there.
All right. How long would you take, Mr.
But I would take about 2 hours. I'll try and
About
curtail it.
2 hours.
I'll try and curtail it. I put my submissions
All
in
right.
writing.
And Mr. Rai?
Lord, I've been through Mr. Kambata's submissions. I have something to add, which I've also put in my submissions, my lord. I had anticipated, my lord, 2 hours myself, but I'll take much less than that. Lord.
Okay.
But
So that means it will not get over today.
yes, my lord, because I have some differences from
What
the
Mr.
other
Kambata
but
is arguing.
even to the,
So today, probably Mr. Kambata will get over today.
yes.
Look,
And then then we can keep this thereafter just to keep the format and the time schedule on the 11th because
Yes, yes.
10th is the
Correct.
miscellaneous
Opening
day.
day.
Next week we have 2 days which are going to be miscellaneous.
Miscellaneous.
10th will be miscellaneous. Then 11th we can take we can hear Mr. Rai for the morning session.
Yes.
Morning session you can wrap up. So then we can conclude
The
the
other side.
matter by the morning session.
Tomorrow is also, my lord, miscellaneous.
Tomorrow is miscellaneous because day after is a holiday.
We're
So
grateful, my lord. The break is a bit unfortunate because it breaks the continuity.
yeah,
flow.
absolutely.
We're grateful.
So
Generally, it is said, my lord, that never give lawyers an overnight to think. The arguments are always lengthened.
which is why it's good everyone's put it in writing.
Alison, you got your compilation and your written submissions also.
We filed it.
So then you can just take us to navigate us.
I will do that.
We'll come back at last. had an administrative meeting and
No,
that
we
spilled
understand.
over a little bit.
We fully understand the.
My colleagues were actually waiting for me, but I had to hold them back as well.
Your lordships are all under, there's no necessity to even say that.
No, just before Mr. Khambata begins.
Yes.
Because I believe your lordships was looking at some kind of time estimate. Now, fortunately for me, Milord, some parts of whatever I have given in my written submissions is also part of Mr. Khambata's submission, so I can certainly skip all of that. I estimate follows about an hour and a half is what I've.
Yes, Mr. Chairman.
The way I propose to go about it, I've heard my learned friend, the Solicitor General, and I've got a full report of what has been argued. And I propose, subject of course to what my lords say, to go about it in 4 buckets of arguments. The first, I think it is necessary for me to go into what the group of companies doctrine really is. And it will be my submission that it is a concept which is founded almost entirely, if not entirely, in the law of contract and requires a mutual intention and an implied consent. It cannot exist outside intention, is going to be my submission.
Mutual intention and
Implied consent of the non-signatory as well as the signatories. Everyone has to consent to the non-signatory being a party. And the second will be that who is a party must ultimately accord or comply with the principles of contract and the provisions of the Arbitration Act. And I will show certain areas where this becomes a little relevant under the Arbitration Act. And it will be my submission there ultimately that the group of companies doctrine will be limited by certain provisions of the Arbitration Act. It's not excluded, but it will be limited. The third is what are the key ingredients of the group of companies doctrine that will be important. And there the submission is going to be that all the judgments ultimately seem to say that the object of using such a doctrine is to find someone who is not signed, but who is what they call a veritable party, effectively a party without a signature. That is the object and end result. And without that end result, there's no intermediate person who can be roped into an arbitration. And finally, and this may be the most important for your lordship sitting in Constitution bench, there are 3 or 4 other very cardinal principles which intersect with this principle. And a balancing needs to be done. And what are those principles? The first is that arbitration is consensual. It is founded only on contract. There can be no arbitration outside contract or consensus. The second is the principle of party autonomy. That arbitration allows parties to decide whether they will arbitrate, and if so, what is the scope of the arbitration and who will be involved in the arbitration. So it is extraordinary. It's not that it can't be done, but it's extraordinary to bring in someone who the parties have not contemplated in the agreement. The third is that there are principles which exist in other branches of the law, which would also have to be balanced. For example, the principle which our Supreme Court has recognized in the Vodafone case, that groups of companies are entitled to structure themselves in a particular manner and hierarchy in order to protect themselves from liabilities and obligations. This is an accepted principle of corporate law. And how is that to then be balanced in a given case with the group of companies doctrine? The balance has to be struck so as not to destroy either one or the other of these principles. Now, in this regard, I want to get 3 or 4 things out of the way straight away. I fully accept that doctrinal concepts or considerations can always be introduced into the Arbitration Act. The doctrine of agency, doctrine of estoppel, doctrine of a group of companies. There's no bar to introducing any of these. And it can't be argued that because sections don't expressly provide for them, they can't be. That can never be in any common law statute. That can never be the position. The second, immediately, that a party need not be restricted to a signatory. That also is I think, fairly clear. The third, that in contract law, a party can become a party to a contract, and a contract can arise by conduct. It need not be signed, or even in writing. It can be an oral contract. And lastly, that who can be made a party to an arbitration agreement will be governed by the Arbitration Act, by Part 1, as far as any India-seated arbitration, whether domestic or international commercial. And the solicitor showed us the recent American Supreme Court judgment, which says the same thing, that it's domestic law that will decide who is a party. So this is the very broad framework. And then, of course, I have reached conclusions in my submissions, which I commend to my lords. But I would first like to start with the genesis of the group of companies doctrine. Our Supreme Court, in at least 2, if not 3 judgments, has expressly said that this doctrine comes from an arbitral award. And that is the only reason I'm reading an award before my lords. Normally, one would never cite an award. But since the Supreme Court has recognized that the genesis of the doctrine is from this award, may I request my lords to see the Dow Chemicals award?
The Dow Chemicals, right?
I have filed a compilation which is serial number 11. My submissions are serial number 5, I'm told, in a listing for my lords. And serial number 11 is the compilation.
Mr. Kambata,
Yes.
as you are opening your argument, I was just going to say, you have said that there could be a group of companies identified as a particular group.
Yes.
And you said that companies are entitled to protect themselves from liabilities.
Yes.
So there could be correspondence, there could be intention, which would say that although I am part of this group, yet I am out of any obligation arising out of contract between A and B. So
Yes.
you will have to sort of, because
I will
this is
go into
something
that.
which you are projecting for the first time.
Yes, I will go into that.
This is important.
No, I will go into that. And how far can a court go in respecting it? There will be some cases where my lord will say, no, the veil has to be pierced.
Correct.
Or this has to be disregarded. I'm not again for a moment suggesting any one of these principles is absolute. There's a balancing to be done. But a balancing has to be done. And what really is happening today, and that is the reason why it's so important the Constitution bench decides this, is perhaps not in the Supreme Court, but my lords, in the High Courts and in tribunals. The attempt now is to look at a group. If you have an arbitration agreement with one entity, you then look at the entity within that group, which is the most creditworthy or which has the most assets. And sometimes on the most peripheral connection, hardly a connection, certainly not a connection that will satisfy any of these tests, that party is open into an arbitration in a non-consensual manner. And that is and using the chloro control principles. Sometimes, of course, disregarding them, but my lords are not concerned with the aberration. My lords are concerned with the principles. And therefore, in any view of the matter, it will become necessary to set down fairly strict parameters. I again accept that my lords should not, down to the last detail, set out a formula. It can't be done. They must leave some play in the joints because these are matters which will alter from case to case. But certain clear guidance is required. Yes. And I will of course come to Justice Roy's question when I'm conscious of that, of how that can be done. And I'll be placing the Vodafone decision before my lords, where this is expressly raised and decided. The Dow Chemicals case is page 1 of this compilation. Do my lords have it?
Yes.
Just the title first. There were 4 claimants: Dow Chemical France, Dow Chemical Company USA, Dow Chemical AG Swiss, Dow Chemical Europe Swiss. The defendant was Isovo. Now, the first two Dow companies, Dow Chemical France, DCF, and DCC, Dow Chemical Company USA, were not signatories to the arbitration agreement. That is the admitted position. Dow Chemical Company USA was the ultimate holding company of this Dow Group, which of course had many other companies in it, but these were the companies that were involved in this transaction. Claimants 3 and 4 were assignees of the original Dow company that had signed the agreement. And they were also subsidiaries of DCC, Dow Chemical USA. Initially, it was signed by Dow Chemical Venezuela, but it was assigned. So claimants 3 and 4 broadly were signatories to the agreement in the sense that they were assignees. They were claiming through under. They were not in this broader concept of group of companies. The first two Dow companies, DCF and DCC, actually intervened and made claims in the arbitration against Isova, saying we are also entitled to make claims. This was a case of a non-signatory trying to join an arbitration and make a claim. And obviously, Isova took a jurisdictional objection saying they have no right, they are not signatories to the arbitration agreement. In that context, my lords, kindly turn to page 2. And unfortunately, these are only extracts. We couldn't get a complete report of the award. But all the authorities seem to suggest that these are the relevant extracts. The extract at page 2 on the top, on the sources of law that should apply. The first para, considering it is not disputed that the arbitration clauses relied upon by the claimants are contained in contracts that have been signed by neither DCF nor DCC, Dow Chemical USA, that these two companies nonetheless maintain that they may invoke them by reason both of the factual context of the conclusion and performance of the contracts and of the fact that these companies, along with the signatories of the contracts, are part of a group of which Dow Chemical USA is the parent company, the three others being its daughter and granddaughters, entirely controlled by the firm. That is one undisputed aspect. The next is 3 paras from the bottom of that page. The paragraph starting, considering that the tribunal shall accordingly determine the scope and effect of the arbitration clauses in question, and thereby reach its decision regarding jurisdiction by reference to the common intent of the parties to these proceedings, such as it appears from the circumstances that surround the conclusion and characterize the performance and later the termination of the contracts in which they appear. In doing so, the tribunal, following in particular French case law relating to international arbitration, should also take into account usages conforming to needs of international commerce, in particular in the presence of a group of companies. Turning to page 3, and this I'll read in somewhat greater detail. The tribunal, after accepting that the claimants were all part of a group of companies, then proceeds to discuss the involvement of each of these in the actual transaction. So para 2 at page 3, after a detailed analysis of the contract negotiations, the tribunal continued by considering A, the negotiation of the contracts, considering that in point of fact, DCF, Dow Chemical France, at the time of signature of the 1965 contract, as well as the negotiations which led to the 1968 contract, appeared to be at the center of the organization of the contractual relationship with the companies succeeded by the present defendant. Moreover, this relationship could not have been formed without the approval of the American parent company, which owned the trademarks under which the relevant products were to be marketed in France. So straight away you have a finding that DCF was at the center of the organization of the contractual relationship, and DCC owned the trademarks without which you could never have marketed those products in France. Then that this analysis reveals that neither the sellers nor the distributors attached the slightest importance to the choice of the company within the Dow Group that would sign the contracts. It is significant to note that none of the documents produced contains any trace of a discussion on this subject. In reality, all the entities of the Dow Group involved in distribution in France understood themselves to be contracting with the distributor or distributors in France, and likewise it was with the aggregate of these entities that the present defendant's predecessors understood themselves to be contracting. So everyone understood that all these companies were really contracting parties. Then be that is the time of negotiation, the entering into the contract. Then be the performance. Considering that, as has been mentioned above, the distribution agreement of 1965 as well as the one of 1968 designed first of all Dow France for delivery of the products to distributor. Although it has been provided for that deliveries could also be effectuated at the choice of the seller by other subsidiaries of Dow Chemical Company, it is to be noted that in fact, it has not been sustained that this option has ever been used. It has always been Dow France which has assured the execution of the contracts. Dow France, therefore, played in the execution of the contracts an equally preponderant role as it did in the establishment of the contractual relationship. So this non-signatory was the center of the negotiations and played an equally preponderant role in the execution of the contract. Considering, moreover, that for exercising its contractual activities, the distributor necessarily needed to make use of the trademarks belonging to the parent company, Dow Chemical Company, though no special license agreement appears to have been concluded. This situation shows the primary involvement of the parent company in the distribution agreements. The same significance can be attached to the clause, which has already been mentioned, and according to which deliveries could be made by any wholly owned subsidiary of Dow USA. The clause shows, in fact, that the parent company was the pivot of the contractual relationship finally established between certain entities of its group and the distributors. Then the third factor, termination of contracts. That it thus appears, as was the case with respect to the conclusion and performance of the distribution agreements, that Dow Chemical France played an essential role in the termination of the 68 contract, which had been substituted for the 65 contract, that all of these factors permit the conclusion that Dow Chemical France was a party to each of these contracts and consequently to the arbitration clauses they contain. So cumulatively, Dow France's involvement in being the center of the negotiations, being the person who actually assured execution of the contracts, and being the company that played an essential role in termination, altogether made it effectively a party, a veritable party. Similarly, the next paragraph, that the same conclusion should be reached with respect to Dow Chemical Company USA by reason of its ownership of the trademarks under which the products were marketed and its absolute control over those of its subsidiaries that were directly involved or could under the contracts have become involved in the conclusion, performance or termination of the litigious distribution agreements. I rely on this para because there's a finding of absolute control. In the Vodafone case, as your lordships have said, that even holding 100% of the shares of a subsidiary ipso facto doesn't lead to piercing of the veil. A legal control is required, something more than a persuasive position. So here there's a finding of absolute control. And then, considering that the defendant adopted the same position in its brief of so-and-so before Court of Appeal of Paris in support of its motion of compulsory joinder of Dow Chemical Company, that the defendant there in fact wrote as follows, where this is Isova, who was opposing the claimant. Whereas Dow Chemical Company, owner of the patents and organizer of the manufacturing and distribution of Roofmate, decided and conceived the modalities of the manufacturing and distribution of the said product, thus engaging its direct liability. So the parent company conceived of all this, the manufacture and the distribution, and therefore engaged in a direct liability. Next page. I'm sorry, the last sentence of the preceding page. Considering that in the circumstances of this case, the application of the arbitration clauses to Dow Chemical Company USA may also be justified, as we shall now show, by the fact that the contracts containing these clauses concern, in the context of a group of companies, a parent company and certain of its subsidiaries. The same fact would justify, if necessary, the application of the arbitration clause to Dow Chemical France, then group of companies. Considering that it is indisputable and is in fact not disputed that Dow Chemical Company USA has and exercises absolute control over its subsidiaries, having either signed the relevant contracts or, like Dow Chemical France, effectively and individually participated in their conclusion, performance and their termination. Considering that irrespective of distinct juridical entity of each of its members, a group of companies constitutes one and the same economic reality, of which the arbitral tribunal should take account when it rules on its own jurisdiction, subject to Article 13 of the ICC rules. Considering in particular that the arbitration clause expressly accepted by certain of the companies of the group should bind the other companies, which by virtue of their role in the conclusion, performance or termination of the contracts containing said clauses, and in accordance with the mutual intention of all parties to the proceedings, appear to have been veritable parties. This is an expression that comes from a veritable parties to these contracts, or to have been principally concerned by them and the disputes to which they may give rise. And then in the next few paras, they say that in fact, there were other awards also, where sometimes it was held that these companies in the group were bound, sometimes it was held they were not. And in one award, they noticed it was not, because there was not that level of involvement. And the last para on that same page, in so doing, the tribunal contradicts no principle nor any rule of international public policy, in particular that of the French legal system. The latter is not based on any principle, nor does it contain any rule of such a stature that would prohibit giving to an arbitration clause implicating companies that are legally distinct but form part of a group of companies the scope attributed to it by the present award. To the contrary, by taking into account, in reaching this result, the needs of international commerce to which the rules of international arbitration should be responsive, the tribunal follows the example of French case law, to which express reference was made in the report to the Prime Minister, etc. So the tribunal is very conscious that all this can be done within the matrix of the law, including French law, which govern who are going to be parties to that. Therefore, what does essentially this award do? It said parties who were not signatories, but who were centrally concerned with negotiation, performance, and termination. Parties who everyone considered were veritable parties. The non-signatories themselves considered themselves to be contracting parties. The signatories considered them to be contracting parties. They would be bound by an arbitration clause and could take advantage of it equally, both ways. Here they were trying to take advantage of it. And the signatory was saying, no, I never signed an arbitration agreement with, how can you let them come and make a claim against me? So the genesis of this doctrine is a mutual intention of all parties, signatories and non-signatories. A mutual intention of only signatories is not enough. An intention only of non-signatories is not enough. And this Honorable Court has followed these principles. I'll show that from chloro controls, etc. Now, it is therefore a theory based entirely on becoming a party to a contract, because an arbitration agreement is a contract, by mutual contractual consent. Everyone has consented by conduct. They've not written it, but by conduct and the way everyone has treated it. And then one of the parties can't back out of such a consent which could be implied constructively from conduct. That is the limited, narrow area of this doctrine. And as a later authority points out, I just want to place that article, that it's a doctrine really that is founded on consent. In fact, the critique of this case is that the fact that it was a group of companies was just one factor. It was really consent that was the main factor. So though the theory is called group of companies doctrine, it's really based on consent and a mutual intention. And I just want to place that article because it's a very good analysis. Please treat it as my submission to your lordships, which is a Professor Hanishu's article found at page 152 of the same compilation. It's written recently on 40th anniversary of the Dow Chemical Award. And I'll just point out a few passages. At page 153 of the compilation, the paragraph on the top, about halfway through that para. The para starts with as to the subjective scope of the arbitration agreements, but about halfway through, rather it found that the non-signatories appeared to be true parties to the contracts. It concluded that this was the intention of the parties, both of the claimants and of the companies which were eventually succeeded by the respondent. The arbitral tribunal followed a two-step approach to determine the subjective scope of the arbitration agreements. First, it analyzed the factual circumstances underpinning the negotiation, performance, running. The first paragraph.
53, the page begins with circumstances.
I'm obliged. Then the next para is as to the subjective scope.
Correct.
So about halfway through that para, the word, a sentence starting with rather. Rather, it found that the non-signatories appeared to be the true parties to the contracts. It concluded this was the intention of the parties, both of claimants and of the companies which were eventually succeeded by the respondent. Arbitral tribunal followed a two-step approach to determine the subjective scope of the arbitration agreements. First, it analyzed the factual circumstances underpinning the negotiation, performance, and termination of the agreements. Second, it considered what bearing the circumstances that the companies belong to the same group should have in that context. Throughout both stages, the arbitral tribunal focused on the parties' intentions. While analyzing the circumstances of the case, the arbitral tribunal found that both non-signatories played an important role in the agreement's negotiation, performance, and termination. Then the one paragraph after that, starting, it was only after the arbitral tribunal reached the conclusion that the non-signatories were also parties to the agreements, that it proceeded to the analysis of the impact that the existence of a corporate group might have upon the arbitration agreements. In this regard, it is important to mention that the arbitral tribunal found that an arbitration agreement signed by certain companies should be binding on other entities of the group only where the latter seem to be true parties to the arbitration agreement by virtue of their participation in the negotiation, performance, and termination of the contract, and if this corresponds to the parties' intent. It's a very important caveat. So it's not that one can just see a group, for example, the Tata Group or the Birla Group. You enter into an arbitration agreement with one company. It doesn't automatically rope in every other company, or you can't pick and choose. It has to be a company in the same group who has been intimately concerned with all these aspects.
Pivotal role is.
Pivotal role. These are descriptions.
Yes.
I'm not, it's
We can't
written
sort of
stone.
choosing a particular
Correct.
word, but then we understand the.
Some important role in negotiation, performance, and even in termination if that is the position. Then if we go to the next page, the section starting with no creation of a group of companies doctrine. Over the last 40 years, much has been written. Over the last 40 years, much has been written about the so-called group of companies doctrine, a theory allegedly originated from Dow Chemical case used to bind third parties to an arbitration agreement. However, no consensus has been reached as what should be understood under the group of companies doctrine. Neither its concept nor its contours are clear. An analysis of literature and case law reveals that completely opposite conclusions have been drawn from the Dow Chemical Award. On the one hand, the group of companies doctrine has been criticized and its application has been rejected by courts and arbitrators that considered the group of companies doctrine a non-consensual basis for extending the arbitration agreement to companies of the same group, irrespective of the party's intent. From this perspective, the theory would be a violation of the consensual nature of arbitration. On the other hand, some commentators take the view that consent is at the heart of the group of companies doctrine. They see in it a basis for finding implied consent based on objective patterns. In light of these conflicting views, the term group of companies doctrine is clearly ambiguous. Hence, it is not surprising that discussions regarding the existence and applicability of such theory quite often lack clarity. Not only equivocal, the group of companies doctrine is also a dispensable concept. The idea that the Dow Chemical Award created a non-consensual basis for extending the arbitration agreement is a misconception. As shown above, decisions rendered by Arbitral Tribunal and Paris Court of Appeal actually rely on consent. They did not give origin to a theory allowing the extension of the arbitration agreement beyond consent. And then the last two paras on that page. Furthermore, Furthermore, had the group of companies doctrine a consensual nature, it would be only an unnecessary term, adding complexity to what is in fact the assessment of the party's intent. Attaching any consensual requirement to the theory would render it meaningless. Consent is the fundamental and utmost requirement in any case. If there is consent, there is jurisdiction, so that no further requirements would be necessary. In other words, if there is express or implied consent, then the party will be a true party to the arbitration agreement without needing to resort to any theory. This does not only apply to cases where the companies are from the same group, but also where the companies are completely dissociated from one another. The existence of a group of companies is therefore only a factual element that might indicate consent towards multi-party arbitrations. It is certainly a factor to be taken into account when analyzing the parties' intentions, but it is not a decisive element by itself. Consent remains the preponderant criterion. And the last page, 155, conclusion. Dow Chemicals award landmark decision. It provides clear reasoning as to the fundamental role played by consent in determining the subjective scope of the arbitration agreement in multi-party arbitration. In this case, the arbitrators decided that the companies might be bound by the arbitration agreement entered into by other entities of the same group if the non-signatory companies appear to be true parties to the arbitration agreement by virtue of their involvement in the negotiation, performance, or termination of the underlying contract. Dow Chemical Award did not create a basis for extending the arbitration agreement to third parties, irrespective of their consent. In fact, exactly the opposite holds true. The arbitrators found that an arbitration clause might bind a party that has not formally entered into the agreement only insofar as this is in accordance with the parties' mutual intentions. This contradiction puts the existence of a so-called group of companies doctrine into question. In 40 years, the term group of companies doctrine has proved to be misleading, and the idea of such a theory a misconception. The fact that two companies are part of the same group does not serve as a basis for the extension of the arbitration agreement on its own. Whether a party can invoke or be bound by an arbitration clause is a matter of consent, which shall be ascertained case by case based on factual elements. This does not mean existence of a group of companies is irrelevant. Quite the contrary. It is certainly an element to be considered in the analysis of parties' intentions, but not decisive per se. Now, I'm adopting these as my submissions. And in my submission, when I show chlorocontrols correctly read, it is what chlorocontrols itself has said in many ways. And the only thing chlorocontrols has actually left out is the requirement of performance, which my lords have now added rightly in the discovery matter, ONGC discovery. That fifth element has now come in. But what is important is that these are cumulative elements. It can't be a pick and choose that they're part of a group of companies. It matters not that there's some peripheral involvement in negotiations. That's all. They are roped in because one or two of the factors are satisfied. These are all to be seen cumulatively. And the conclusion has to be reached that with these factors, there's an implied consent and they're true parties. Without that conclusion, there can be no joining of any party to an arbitration because that would defeat another cardinal principle of consensuality. A non-signatory might say, I never agreed to go to arbitration. A signatory might say, I'm sorry. When I show the provisions of our Act becomes very critical. Because our Act requires the provisions of the Contract Act to be complied with. So without consent, you can't have a contract. If my lords would kindly now turn to my note, maybe quicker if I, some portions I will just take from my note. I don't want to trouble my lords to see. Everything is here in the compilation, but if one would kindly go to page 4 of the note, the passage marked common intention. I've referred to the UK Supreme Court decision in the Dalla case. This is a case on slightly different facts because here it was a very odd case, my lords of course know, where award arbitration seated in France came for enforcement to England. England has special laws where jurisdiction is tried de novo in court by the enforcing court, with evidence being led and everything. So they held a mini trial, and they held contrary to the tribunal, saying, no, according to us, tribunal had no jurisdiction, we won't enforce this award here. 1 month later, the court of the seat in France affirmed the award. So it's that case. But in that case, they had occasion to comment upon what the French law was. And I'm only relying on those observations because they are relevant to our case. So the UK Supreme Court was applying French law to test whether an arbitration clause, this is para 8 of my note, whether an arbitration clause upon which the jurisdiction of the tribunal is founded extends to a person who is neither a named party nor a signatory to the underlying agreement containing that clause. And I quote, the Supreme Court held, whether all the parties to the arbitration proceedings, including that person, had the common intention, whether express or implied, to be bound by the agreement. This was a case where the Pakistan government had set up some public trust, and the contract was entered into by the trust. The other company, which was a Saudi construction company, said effectively we are dealing with the government. This trust is only an instrumentality of the government. And though the government may not have signed the arbitration agreement, we are entitled to join them to the arbitration. Government of Pakistan took a jurisdictional objection, saying we are not signatory parties. So under French law, this was the analysis of the French law done by the UK Supreme Court even, which said, therefore, all the parties had to have the common intention. And then the common intention of the party in turn means the subjective intention derived from objective evidence. Objective evidence includes the involvement and behavior of all the parties during the negotiation, performance, and if applicable, termination of the underlying agreement. Then Redfern and Hunter said effectively the same thing. 3 conditions: whether the non-signatory actively participated in the conclusion and execution of the contract. Second is, has a clear interest in the outcome of the dispute. And 3 is a party to the contract that is intrinsically intertwined with the contract under which the dispute has arisen. And Gary Bourne has said the same thing, that at bare minimum, the non-signatory's intention is the most important. The signatory's intention will be housed in the contract. My lords know, as a matter of interpretation of contract, one sees the contract primarily. So that intention is easier to ascertain. It's the non-signatories that's more difficult, and various tests have been evolved. And I've just for convenience shortly put out in para 12 what your lordships did in chloro controls. In para 71, if the circumstances demonstrate that the mutual intention of all the parties was to bind both the signatories and the non-signatory affiliates, and where there was a clear intention of the parties to bind both signatory and non-signatory. Now, if this is the doctrine which our Supreme Court has squarely accepted, derived from Dow Chemicals, your lordships have said mutual intention is a requirement. Maybe now with this background, turn to the Arbitration Act. Where does it fit in under our Arbitration Act? My lords will recall only one thing. Arbitration is a statutory exception to the doctrine of restraint of legal proceedings. Section 28 of the Contract Act has an explanation saying, other than arbitration, any contract in restraint of proceeding will be void. So it saves a contract from voidness, that it has to be an arbitration agreement.
Mr. Khambhata, I would like to read your note at page 6 because we formulated it, and then you can.
Yes, may I read that?
That will be.
So may I read from the bottom of page 5?
Yes.
An arbitration agreement excludes the jurisdiction of a civil court, including under Section 9 of the Code of Civil Procedure, and takes away the right of a person to approach a civil court. Such an exclusion can be made either by statute or by contract only. An arbitration agreement, therefore, must satisfy the requirements of the law of contract, which is the Contract Act. Under Section 2 of the Contract Act, the following would be essential for formation of a contract. 1, a proposal. 2, acceptance of such proposal, making it a promise. 3, a promissor and a promisee. 4, consideration for the promise. 5, reciprocal promises forming an agreement. And in Vidya Drolia, your lordships held that an arbitration agreement must satisfy the prerequisites of a contract under the Contract Act. That is, in addition to Section 7, it must contain promises forming the consideration for each other. it must be made of free of consent between parties competent to contract for a lawful consideration of the lawful object, and it must be enforceable by law. Now, straight away when we talk about contract and third parties or non-signatories, doctrine of privity comes to mind straight away. The third party can never enforce a contract, nor can it be bound by it. And there are various well-settled exceptions to that. Our Supreme Court in MC Chaco has said third party cannot sue or be sued unless the exceptions to the doctrine such as trust, family arrangement, assignment are attractive. Not for convenience, I'm not going to take him out, but some of the important cases we have graphically analyzed in annexures. It's just because some of the facts are usually so complicated that it's easier to do it by way of a graphic, and therefore we analyze MC Chaco, where Kottayam Bank was not a party, and it was held it's neither a beneficiary of a trust nor part of a family arrangement. It was not allowed to enforce a contract whereby members of a family had agreed between themselves to pay off dues to Kottayam Bank. Now, privity of contract and the exceptions to it, both under our law and English law, does not admit of this so-called group of companies doctrine. There is no such exception. So, the group of companies doctrine is something outside the law of privity of contract. And it seems to be on a slightly different basis. Privity of contract is a third party to a contract cannot enforce or be enforced against it. Group of companies doctrine says this is not a third party. This is effectively a party, a real party. So unless you reach that conclusion, one would fall foul of the doctrine of privity. The court has to reach the conclusion that this is a real party or a veritable party. Short of that, a factor here or a factor there is not enough. Now, may I proceed further, para 19. Arbitration in agreement in restraint of legal proceedings would be void, section 28. Specific exception is carved out for arbitration. Exception 1, saving of contract to refer to arbitration disputes that may arise. This section shall not render illegal a contract by which two or more persons agree that any dispute which may arise between them in respect of any subject or class of subjects shall be referred to arbitration, and that only the amount awarded in such arbitration shall be recoverable in respect of the disputes so referred. Therefore, two or more persons are required, and they must agree to refer any dispute which arises between them to arbitration. So the non-signatory party must come within these two or more persons. That is to say, it must be treated as a party. Short of reaching that conclusion, one can't rope in a non-signatory. And because there is, my lords know, I have not cited this, well settled, Arbitration Act is a complete code. It's exhaustive of the law of arbitration. So unless it is a valid arbitration agreement under the Arbitration Act, there's no other arbitration outside the Arbitration Act by which one can bring in a non-signatory or non-consenting party. Now, even enforcement of a contract, this is interesting in the Specific Relief Act. When we are dealing with companies, there are only two categories that have been roped in addition to parties. Section 15, which is who can enforce a contract, permits enforcement of a contract by a non-party company in only two cases. One is subpara G, amalgamation. So company A enters into a contract, ultimately amalgamates with company B, and the amalgamated company can enforce that contract. And H is pre-incorporation contracts, when promoters enter into it before incorporation of the. Again, the Specific Relief Act has no such category or residual category even of a non-signatory company because it belongs to a group and it may have been involved in something becoming a party which can get specific performance. And Section 19 is the other way around. Against whom can you obtain specific performance? Again, only these two categories. So again, I point out, I'm not for one moment suggesting that the group of companies doctrine still can't be incorporated, but it has to reach the result of a conclusion by the tribunal or by the court that this person is nothing but a party. Only the formality of signature remained. Short of reaching that conclusion, There is no way within our matrix of law that one can bring in another type of hybrid type of a party against whom or who can enforce specific performance. Now let us come to the Arbitration Act. Because in my respectful submission, the Arbitration Act actually narrows what is found in the Contract Act. And I'll tell my lords why. 2(1)H only says party is a agreement. There's no restriction there, and there's no restriction of signatory. Can be someone who doesn't sign. 2(1)H, we've seen, does not incorporate the Law Commission's recommendation of claiming through order, but at a certain level, that's not critical to your lordship's analysis. Because we are seeing claiming through order is a derivative character, whereas here we are trying to see who is the real party or the true party, which is not a derivative character. In a derivative character, the cause of action would belong to the original signing party, and only someone claiming through order in that very character would come in. Whereas here we are saying the third party who has not signed has its own cause of action, or there is an independent cause of action against it, not derivative. Therefore, this point is there, we've argued it, but at a certain level, my lords may take it that true order is not determinative of the answer to this question that faces the Constitution bench. Now, I've set out from paras 23 to 27 this concept of the definition of party. In para 28, of course, I've referred to the requirement of consent and the party autonomy being the backbone. As one US Supreme Court judgment had put it, arbitration is a matter of consent, not coercion. Puts it very nicely. There's no mandate of the law that you are a party. It has to be housed on consent and founded on. Without consent, you can't have arbitration, unless it's a statutory arbitration. That's a different category. Now, please see may I just show the provisions of the Arbitration Act?
Yes.
If one goes now to section 7, what we were just saying this morning. 7(1). In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes. I pause here for a moment. These words describe the contract of arbitration, the arbitration agreement. Now, the following words say what the character of those disputes could be, which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. As my Lord the Chief Justice said this morning, this is the source of the dispute. And that's a nice way of putting it. The subsequent words are, where does the dispute come from? It must come from a defined legal relationship, whether contractual or not. And one can think, in fact, it fell from the bench in the morning. There are various examples. Quasi-contract, section 68 to 72. All those, quantum meruit, monies had and received, all those are not contracts, and yet a dispute could come from them. Family arrangements, partition suits, all those are disputes where there is no contract. Trust could be another area. And of course, now there is a fourth area, which your lordships in Vidya Jolia have contemplated, that even in personam disputes arising out of an in rem right can be the subject matter of arbitration. So it could be an IPR dispute, where whether the trademark or the patent is validly registered can never go to arbitration. That's a matter in rem. But if there's a dispute between parties or an infringement dispute, that could potentially go to arbitration. It's an in personam dispute. Again, that sort of a dispute is not housed in a contract. It could be from a license agreement, but it could be just two parties using the same mark. Therefore, the Act rightly says that you need an arbitration agreement, which has to comply with the Contract Act. That agreement can be in respect of either contractual disputes or even non-contractual, as long as there's a defined legal relationship. Now, that's all right. That's all right. 7(3) says an arbitration agreement shall be in writing, and 7(4) says an arbitration agreement is in writing if it is contained in A, a document signed by the parties that requires signature, B, an exchange of letters, telex, telegrams, or other means of telecommunication including communication through electronic means which provide a record of the agreement, or C, an exchange of statements of claim and defense in which the existence of the agreement is alleged by one and not denied by the other. Now, it is going to be my submission, and I hope I can make it good, that 7.4 is exhaustive of 7.3. And I'll show from the UNCITRAL model law and from other statutes why this is so. In other words, the agreement in writing has to be in one or the other of the three forms, A, B, or C. And straight away, may I say that this itself does not exclude the group of companies doctrine. Because B, for example, exchange of correspondence, it can be that a non-signatory party has exchanged that correspondence where it is effectively shown that it's a true party.
But 7.4 may not be exhaustive of 7.3. 7.4 may be an illustration of 7.3 also.
That is a possible argument. My lord is right. But please, if my lord sees my note.
Because 7.3 says that an arbitration agreement shall be in writing. It's the norm.
Correct.
And 7.4 provides for instances
exactly.
where an arbitration agreement is.
Exactly.
Of course, there's one thing which is there, which it doesn't say it shall be deemed to be in writing if. It says is in writing if.
If it is contained. The word if is used. And something may turn on that. So I want to place before my lords the UNCITRAL model law.
But it's not necessary for us to unduly restrict 7.4 by saying that these are the only instances where an arbitration agreement will be deemed to be in writing.
I understand that. That, of course, your lordships will determine. But may I just place some material which might be of assistance to my lords in that exercise? In my compilation.
I'll tell you why.
Yes.
This was actually worrying me in the morning. 7.4b refers to an exchange of letters, telex, telegrams, or other means of telecommunication, which provide a record of the agreement, right? And C then refers to claim and defense. Now, B provides an extremely limited. A is a document which is signed. B refers to only an exchange of letters or electronic means of communication. Now, there may be other circumstances where there is no exchange of letters or an electronic communication or a physical communication between the parties. Where, for instance, I'll tell you, suppose there's a measurement book in a contract. That measurement book will not fall either in terms of a document which is signed by the parties. It will certainly not be an exchange of letters. It will not be an exchange of statement of claim or defense. So there may be other conceivable circumstances in which parties may, by writing, agree to an arbitration, which is neither a letter or exchange of correspondence, nor is an exchange of a statement of claim or defense, nor is that document signed by the parties, but which may still be in writing.
I see what falls from my lord.
It could be a record of
agreement.
But it's a record of an agreement.
So long as it is a record of the agreement.
That's right.
That's why I told you a measurement book.
Correct.
So measurement book
So
between the
therefore,
parties.
these three instances which are prior to record of an agreement is not exhaustive. The keywords are record of agreement.
Correct.
What is a record of agreement? There are instances like exchange of letters, telex, telegrams, and other means of telecommunications, including through electronic mode, are instances of record of agreement, which could be.
And therefore, B could be
And
read.
the absence of the word only in 4.
Yes.
Is again, just as you have the absence of the word signatory in 2.1a.
Yes.
And the absence of the word only in 7.3, in 7.4. But an arbitration agreement is writing only if it is contained.
Correct.
Then you would have been right. But
Some
that
point
word only is absent.
may be obtained by seeing the UNCITRAL model law, which underwent a change. I'll show both. Because our act is based on the model law, and your lordships have held repeatedly that the model law is an appropriate guide to interpretation. It can be looked at. If we just see the model law as it first was, in 1985, that is page 637 of this compilation. What is the equivalent provision there? And then what is the change?
I have one small doubt.
Yes, sir.
See this expression, the real rubric which you are placing so much reliance on is consent, correctly.
Yes.
But then consent is also a little amorphous. Should it not take color from the Contract Act till it actually becomes a contract? That is, should it also definitely not constitute principles of promise?
Yes.
Which is, should it not have offer and acceptance?
Yes, I'm obliged. I'm
So
obliged.
therefore, one has to see under the definition of 2E, F, G, H, I, leave alone J of the
Correct.
Contract Act,
My lord is right.
where a third party becoming a part of an arbitration, it needs to be concluded by the court that there is the semblance of reciprocal promises or offers and acceptance leading to an agreement.
Yes, I'm obliged.
You don't need any further.
I'm
Leading to
obliged.
an agreement, and all this could be sourced from the record of agreement.
I'm obliged. But may I adopt that as my submission? I put it a little inartistically. My lord is
That
right.
must be there.
Yes,
It's not just saying the consent is there means consent.
correct.
is What
It has to be a consent
consent can't be
amounting
any
to contract,
consent.
which is why
Consent evidencing. Let us use this very expressions. Every set of promises forming the consideration
yes,
from each and for each other as an agreement. Promises which form part of the consideration or part of the consideration for each other are called reciprocal promises. An agreement not enforceable in law will be void. An agreement enforceable is a contract. So at least offer and acceptance. It again, Contract Act defines offers and it also defines acceptance and how it is completed.
and an arbitration agreement has to first be a contract.
And again,
No, it
consent.
not be a contract. Sorry.
It may or may not be a
It
contract.
need not be a contract. So that is another doubt I have.
That's 7.5.
No, my lord. May I then
Seven
show
five.
things and I'll come back to- because your lordships in Vidya
The
Dholia.
contract may not
Yeah,
contain
no,
an
yeah.
arbitration.
Contract like Vidya Drolia, general observation that it's a contract, but it does not really, they have not gone into it, to be fair to the bench. The question didn't arise in Vidya Drolia as to whether Arbitration Act is confined to a contract, which is agreement enforceable by law.
Maybe see 7.1 again for a moment.
But that's not really a.
I understand. No, I mean, these are issues that will arise. I invite such questions because this is correct. It enables me also to formulate.
Good, actually, according to me, Arbitration Act must be wider than what Contract Act.
My lord,
provides, so that you can
arbitration-
have an arbitration even with respect to non-contractual relationships.
No, of course. I'm sorry. That's why let's go back to 7.1. I'm not saying that you can't have an arbitration agreement in respect of a non-contractual dispute. That's not my submission. 7.1, an arbitration agreement
It's
has
a matter
to
of
be
contract.
a contract. But it can be, I agree to arbitrate disputes of partition, a family matter. I agree to arbitrate disputes of quantum merit.
One is what can be the subject matter of the arbitration.
Yes.
The second is whether to go to arbitration.
Has to be a contract.
The contract.
Has to be.
Once parties have, what you're saying is, once parties have agreed to go to an arbitration, then the context of the arbitration, the
I'm okay.
content of the arbitration
Can be much wider.
Well, it may be, as I said,
Can be much-
between two brothers on partition may be the subject.
In fact, it's not in public, it will be contrary to public policy to narrow that content.
So in other, sorry, sir. In other words, section 7,
Yes,
you're saying arbitration, the heading is arbitration agreement.
agreement,
So you're saying it should be read as arbitration contract.
contract. Yes. And that is the basis of any arbitration. It's very well settled that arbitration is a contractual means. As I said, apart from certain statutory arbitration, which are matter of statute.
The MSME Act.
Correct. That can be different. I'm not saying that is overridden. In fact, the Arbitration Act itself contemplates statutory arbitration.
Or in Madhya Pradesh, you have a statutory form of arbitration.
Correct.
For all public disputes.
Correct.
That's different.
That's different. I'm not saying that, of course, that works. We are talking about contractual arbitration in part 1. And section 7 deals with contract meaning the arbitration agreement has to be a contract, but that contract can allow arbitration of disputes not only in contractual disputes, but other disputes as well, as long as there's a defined legal relationship. So I'm not for a moment suggesting that the scope of the
But
agreement
really, the group of companies doctrine is an effort to locate who is a party to the
is the
contract.
party.
Right. And in locating who is a party to the contract, you go beyond the signatories to the contract, where
Yes.
the conduct of the party, which again has to be evinced in writing, having regard to the provisions of Section 7, shows that there was an intention to bind non-signatories both by parties who are signatories to the document as well as the third parties who are not signatories.
So for example, it could be that a non-signatory has an exchange of letters, telexes, etc., recording the arbitration agreement and indicating that it impliedly that it's consenting to it. That would come within the doctrine. It would come within our Section 7. I'm not saying it wouldn't.
So suppose there's a contract between A and B.
Yes.
And C has aliened by its conduct or whatever, indicated that I affirm this contract,
Yes.
that I stand by this contract.
Yes.
And how do I stand by this contract? Either in terms of the stage of the negotiation of the contract, the performance of the contract, or the termination of the contract. In which event, C has clearly indicated that, well, it is really as much a part of the contract as A and B.
I'm okay. That is my argument. So mine is really a mid path. I'm not on this side or that side. Look, someone asked me this morning, are you for group of companies or against? I said, I can't answer that question because my argument is an intermediate argument.
No, but you are not saying that there is no group of companies doctrine in our law at all.
I'm not saying.
You accept the fact that there is a group of
Yes.
companies doctrine.
Yes.
That this is really a legitimate extension or it is within the statutory mandate. But the contours of the doctrine have to still comply with the essentials of the.
Yes, with Section 7 and of course with the provisions of the Contract Act.
Group of companies is not instant.
One more question. One of the interveners, one of the young lawyers argued it on this, I think Pallav Mongia, I'll just tell you who. Why confine it only to parties who are part of a group of companies then?
That is in fact what Professor Hanushu's article also says. That it may not be confined to parties within a group. The group of companies doctrine is evolved in this manner.
You are sourcing from these statutory.
Makes it a little easier in terms of the fact that the benefits of the contract are emanating within an.
It may be one of the factors. There's no question. It may be one assistance to a person determining whether this is a real party or not. But take a totally different case, a back-to-back contract. Where the two A has a contract with B who has a contract with C. So AB is back-to-back with BC. Now A and B may not be part of the same group at all. They may be totally independent companies.
They would still be bound.
But if one could show some correspondence where A commits to C that I am bound by your contract with B and the arbitration clause in an implied way. I'm not saying the language has to be so express. Then one could say that A is also bound by that arbitration.
Irrespective of whether A and C were part of the same
group or even whether A and B were part of the same group. Yes. Yes. So it boils down to finding a contract by conduct or consent. And one of the factors which may assist along the way is it's a group of companies.
Group of companies could then be just one of the factors, but here by conduct and consent.
Yes.
People who may not otherwise be seen as a group.
Precisely.
Would also be roped in.
Precisely.
So if that happens, then this group of companies doctrine could just be an element in analyzing whether they could be roped into an arbitration proceeding.
Precisely.
So the existence of a group of companies is not a sine qua non for bringing a non-signatory to an agreement within the fold of the arbitration agreement. The existence of a group of companies may be an additional factor
correct,
to show that because they were all part of one economic entity, the broader corporate group, for instance, therefore, say a parent stood by the contract which its subsidiary was entering into or an affiliate was entering into.
That may assist the tribunal or the court. But That's not the search is for finding who is the true party. Is it a true party?
It's in other words evidentiary and not normative.
Precise. And that will subserve the corporate law principle that a group structure can be devised.
I was just recalling this Competition Act Section 3
Yes.
talks about the definition of anti-competitive agreements. Just generally, I
Yes.
may be wrong, but I'm just sharing. It encapsulates the concept of what are anti-competitive agreements. Having said that, it gives 5 instances, which are actually cases where bid rigging, collusive rigging, and so on. So those are actually per se cases. If there is a case of bid rigging, automatically it will become.
That's right.
Like in this case, a group of companies and certain other instances will automatically be, but it has to be actually sourced to the definition of the statute to see if those conditions are satisfied or not.
Yes. The problem for why I'm raising this is, what is happening is groups of companies, you may have even a common promoter. I'll come to that later. What is happening is we have a group of 2 companies with a common promoter. One has entered into the agreement. The other is not a signatory. There are no obligations under the agreement, nothing. And they said, no, it's the same promoter. And therefore, it must be party to an arbitration. And with all the consequences. And listed entities are being dragged in. In fact, I'm appearing in a matter where it's a listed entity. It's dragged in on this ground. Therefore, there is need for some indication of what this concept means.
This concept means, again, we will have to be very, very clear about this. Consent.
Consent.
So then one has to pronounce the contours of a consent.
Yes.
So do we go back to the definition of Contract Act and then?
Yes, my lord. I would think that is necessary because.
Yeah, we will have to go to that. In every case, do we have to see which is the offer, which is the acceptance?
One would
What
have
is the
to.
consideration?
One would have to. Consideration is slightly different. As my lord knows, under our act, it can move from a third party also. From the promisee or any other person, 2(1)D of the Contract Act. So to that extent, it's not such a strict that there should have been consideration. But that test has to be applied. Question is, for example, a non-signatory member of the group. What is the promise it has made? It has to be seen. It's not a promisor. It's not a promisee. How does it get drawn into a contract of arbitration?
The court has to infer from contract to contract.
Yes, that is case.
Agreement to agreement.
That will be case.
So court will only be stepping into the analysis of the agreement and then saying, I will assume that this benefit A gets, the fallout of it is actually on C, who is eventually getting the benefit. So therefore, this works as a consideration.
But
And-
there also,
and,
my lord, there are 2 ways perhaps. One is beneficiaries. If there's some kind of a trust, then there have been a standard exception to doctrine of privity. You don't need to even go to group of companies. But say there is some indirect benefit. Does that make the person a promisor or promisee just by getting that benefit? One may be able to trace the various other instruments available. But does it make it a contract for arbitration? That is a question that has to be answered on a case-by-case basis.
some presence or semblance must be identified.
Must be something.
We
It
don't
has
have
to
to
be.
get into too much of it.
Otherwise, we are undermining the whole concept of arbitration. My concern is,
Well, see, we shouldn't make it too restrictive also, Suppose A has entered into a broader agreement with C.
yes, ma'am.
All right. C has entered into a broader agreement with A. So now A has entered into an agreement with B. C stands behind the agreement. C is interested in the success of the agreements which A will enter into with B, C, with B, X, Y, Z, because that is central to C's contract with A.
Correct.
Now, if C enters into the contract with A, conscious of the fact that the business venture between C and A is dependent in turn on the success of the venture between A and other third parties, and conscious of that, C holds out a representation that, look, I am there.
Yes, that my lord is right. But that would fall under an estoppel. A benefit estoppel, which is a different concept. And there I must tell my,
But these are all, in that sense, they're all,
Case to case.
and these are all related concepts. Therefore, group of companies is not the only point, is not the only situation in which you
Correct,
can
but
include
therefore-
a non-signatory to the
therefore, one
arbitration.
would have to say that an arbitration agreement has arisen by virtue of an estoppel, and then the next question would be whether Section 7 covers such a contract. One may be able to sue the person on the grounds of estoppel. That you made this representation, I entered into this contract, I have suffered loss.
Therefore, Mr. Tushar Mehta had sort of A, B, C, D, E, F.
Correct. But today, seeing only our arbitration act, all those concepts can't be brought in unless they fit the bill under Section 7.
Obviously, you
It
have to come
so,
under.
so the representation has to be in an exchange of letters. It can't be oral, for example.
No, the
It can't be oral.
The question is to identify the principles for fitting the bill, because when we lay down the law, it should be, there must be some amount of certainty. So
Yes.
what is that minimum content that we
The
are?
minimum content is that
Describe is what is
there
important.
must be a contract in law which is entered into by the non-signatory by virtue of his conduct. But that contract to enter into arbitration has to be established. And the arbitration agreement can be housed in a document to which it is not a signatory, because there is a record of the arbitration agreement. So simple case, A and B have a signed arbitration agreement. C can say in an exchange of letters that since I'm completely involved in the performance, etc., I accept that this is how our disputes will be resolved.
I think easier way to define it.
It need not sign. It could be a non-signatory party stated.
You can say 7.3 really is the norm, that it is.
But
to be
before
an
that, may I just show one thing?
And 7.4 is the evidentiary burden that you have to discuss.
But yes, but please see the UNCITRAL model.
When it is deemed to be.
That
when
throws a
it is-
lot of light on how to read 7.3. Please just see the UNCITRAL model law at page 637 of the compilation, just for a moment. So that may assist your lordships in how to interpret this.
I was just talking to my young brothers, we need not pressurize you to conclude today.
I won't be able to conclude. Quite
So
frankly,
no problem. We also have been asking questions. I mean, the reason we were asking questions, that helps us to regurgitate our own thoughts also aloud. And so how long roughly would you take on the 11th?
about an hour and a half.
An hour and a half. So if we start at about 11ish on, you can 12:30, you can.
Yes, whatever. I'm in my lordships. Whenever, or whichever day, whenever I.
Because 5th, 6th, we have miscellaneous.
Yes, sir.
And then-
11th, my lord. Whenever, what is coming?
We have
The first part of the country, one has to be here. There's no question of.
But 11th, we'll have to wrap up 11th
Yes.
because
We-
then
I'll-
following week we are starting with
Same-sex marriage.
Same-sex
Yes,
marriage. We are
yes.
starting. We'll especially fix that matter.
In fact, as regards showing judgments, I only intend showing 2 or 3. The rest I've referred to in my note. I'm not going to repeat.
Now, what you wanted to show?
Yes, please see for one moment. 637. 637.
In
of
your
the
compilation? In your compilation?
In the compilation, Article 7 of the UNCITRAL model law.
737.
Yes, 637. 637. And if we see Article 7, 7.1 is really similar to our 7.1, but 7.2 houses both our 7.3 and our 7.4 in one. It says the arbitration agreement shall be in writing. And it goes on to say an agreement is in writing if it is contained in a document. Now, please see the amendment that was made to this in 2006, which we have not incorporated in our act. And that, my lords, will find at page, same compilation, page 641
That is the amendment of?
of the UNCITRAL model law, which was amended in the year 2006, but we still follow the old definition. And the difference may indicate what the original definition, which we follow, was meant to signify. So the new definition on the 7 is 7.3. An arbitration agreement is in writing if its content is recorded in any form, whether or not the arbitration agreement or contract has been concluded orally by conduct or by other means. Much wider. We don't adopt this definition.
Just 1 second. Can we read it again?
7.3 at page 641 says that the amended UNCITRAL is an arbitration agreement is in writing if its content is recorded in any form,
Including orally.
much wider, whether or not the arbitration agreement or contract has been concluded orally or by conduct or by other means, which also shows that the three means prescribed in the original UNCITRAL model law, which we have adopted, are the three means by which the law intends the arbitration agreement to be.
But not the only three means.
I'll leave it to you.
Mr. Kambata, you're right. I mean, frankly, there is intrinsic evidence to support your interpretation because it says an arbitration agreement is in writing if it is contained.
If it, because
That's a clear
if
indicator.
these are not the three means, then why would we list out?
I know, but we can still
Leave it to your
bypass
lordship.
it in the
I'm not pressing it beyond the point. That is for your lordships. I'm just.
Justice requires us not to accept that.
But just one last
It's an
thing.
evidentiary requirement.
Please see the equivalent provision of the New York Convention.
Where is that?
Page 693 of the same volume. Article 2.2. Again, a much wider definition.
693.
Article 2.2, the term agreement in writing shall include an arbitral clause in a contract or arbitration agreement signed by the parties or contained in an exchange of letters or telegrams. Shall include rather than if.
Article 3.3, is it? Bottom.
2.3, 2.2, I'm sorry, 2.2
2.3.
at page 693.
2.2.
2.2. These were all available definitions. Parliament adopted the strictest of them all in our 7.3 and 7.4, which is retained even today. And your lordships have also held, or such, I can't say held, in all fairness, it has been suggested in your lordship's judgment in both Discovery and Charan. I'll place those, not specifically decided. I'll be very clear. I cannot go so far as to say your lordships have decided this. Your lordships have not. But that is the suggestion that 7.3 is colored by 7.4. As my lord said, that's the evidence by which you prove 7.3.
One other way of looking at it is that 7.1 is actually defining the relationship in terms of defined legal relationship.
Yes.
7.1, defined legal relationship. As long as through the documents and what is specified under B, 4B, through the record of agreement, it could be shown that there has come into existence a defined legal relationship. In sense that there is a relationship which is existing, which is authorized by law, not something which is illegal.
Yes.
Something which has come out of the relationship between A and B, which has an implication on C, and that legal relationship has come into existence is sufficient to call it.
Is sufficient, provided there's an agreement that disputes from that legal relationship.
Agreement is again inferable. That's of course that's taken. Agreement is inferable from.
No, I asked myself, what if there's an exchange of letters where two parties say we'll become co-owners? That's a defined legal relationship. But they say nothing about how their disputes are going to be resolved. That the arbitration agreement has arisen. There still has to be some agreement as to the arbitration agreement.
Yes.
realized.
In Dow Chemical, they were meant, you just described the claimants, Dow USA, Dow France, and the Venezuela, and I think the Swiss company. But somehow I found that very interesting. They are part of a group of which Dow Chemical USA is the parent company. The three others are the daughters and granddaughters. So expecting that the grandfather would stand by or should stand by. And in that case, the grandfather should also be liable for the.
And the grandfather had all the trademarks. Without those trademarks, that could never have been performed.
That's right.
Well, what is right of
So we'll continue on the 11th.
I'm grateful to my lord.
After Mr. Gupta, then Mr. Diwan will.
I would address your lordship.
And then we'll hear.
Whoever's there, start.